The first item is we would need a motion to approve, execute the minutes for work session of the 19th of December.
So moved. Second?
Commissioner Claypool?
Yes.
Aye. And number 2 is requesting the board approve and execute minutes for the emergency meeting on the 21st of December.
So moved. Second?
Commissioner Claypool?
Yes.
Commissioner Leonard?
Yes.
Commissioner Spillier?
Abstain. Okay. So then we need a motion to approve the minutes for the meetings for December 28th, January 4th, and also the January 9th meetings.
So moved. Second?
Commissioner Claypool?
Yep.
Commissioner Leonard?
Yes.
Commissioner Spillier?
Alrighty. So that takes care of that. Good.
Okay, so I'm going to report on a few things here. January 9th, 2018, Resolution 18006 included a cash transfer from the General Fund to Court Technology to pay for a portion of their 2018 funding. And there was a contract purchase order from the Maintenance Department for Geauga Mechanical for a furnace in the dog warden's kennel, as the previous one was shut down and needed to be quickly fixed. So that was on January 9th. On January 10th, Resolution 18-007, I approved a encumbrance for a travel request from the Juvenile Court for John Ralph to attend a supervised child protection visit to Pickens, South Carolina between January 10th and 13th of 2018. So those are the financials. And then item number 7, I'm reporting on an item that I approved on the 16th, authorized by Resolution 18003. And that action, on your behalf, I concur with what Chester Township trustees in not requesting a hearing on the liquor license requested by Spence Petroleum LLC, doing business as Sunmart, located at 8247 Mayfield Road, Chesterland. The permit number CTRFO 8429745.
They ought to be out of liquor licenses in Chester. So they should be out of liquor
Should be out,
licenses.
well.
They've used all one once, I think.
Well, it's a transfer.
What's that?
It's a transfer.
Transfer.
Transfer of ownership.
Yeah.
I think it's used.
Alright. Okay, Adrian, all set.
The financials for today include revenue certifications for probate court and the transit department, a supplemental for $50,000 in the sheriff's department rotary account for equipment. Cash transfers include a cash transfer from the general fund in the amount of $9,301.33 for the December windstream bill. Cash transfer from the general fund in the amount of $14,843.50 for the 2018 Sheriff VOCA grant local match. Cash transfer from the general fund in the amount of $45,845.62 for community development to cover second, third, and fourth quarter payroll admin and a portion of their 2018 funding. Another cash transfer from the general fund to the transit administration fund as an advance for a reimbursement grant funds that have not yet been received from the state in the amount of $82,280, which shall be paid back once grant funds are available, or no later than 12/31/18. And then finally, a cash transfer from the general fund in the amount of $111.75 for the DD gas well proceeds from the fourth quarter of last year. Encumbrances include then and nows from the building department for 2017 expenses not carried over. That was the building department had intended to carry over several balances. They wrote C/O, which they intended to say carry over. It was interpreted as
Close out.
CLO for close. So several encumbrances that they wanted to carry over ended up getting closed. The only way the auditors could find to correct the situation is to do several then and nows, which they had the encumbrances, they had the appropriations, so should be no issue. But We're approving the encumbrances today, right now, and we'll probably be paying these in another special financial either later today or early tomorrow morning, just so you're aware of that. There's also travel requests from the emergency services to attend the radiological emergency planning courses in Columbus. A travel request from JFS to attend the Ohio JFS General Session meeting in Columbus. And a travel request from CASA to attend the 2018 National CASA Conference in Boston, Massachusetts. There's also a purchase order from Water Resources for the purchase of a 2018 Dodge Ram cargo van. Couple of the vouchers of note, $60,280 from the auditor's REAF fund to Integrity Appraisal Services for their 2017 retainage. $104,105 to Ravenwood Center from the Commissioner's Office for the Youth Center funding, and also $29,960 from Water Resources to CSJ Tech for contracted computer repair services.
Okay. Any questions and a motion?
So move for the financials.
Second, yeah.
Commissioner Claypool?
Yep.
Commissioner Lennon?
Yes.
Commissioner Spillier?
Aye.
Thank you.
Thank you, Adrian. Sir.
The next one is from Adrian. You want to stay for
Oh, well, yeah.
number 9? Your domestic violence.
This is something that the commissioners have been doing every year, where they take the remaining unencumbered funds from the domestic violence fund, the 2070, and that money is taken out of that fund and then donated to the Women's Safe Shelter. So we're doing what we've basically done in the past, helping them out.
Plus a
the
requirement
proceeds of
that those
fund.
monies be put toward whoever is designated as the shelter. It's
Correct.
women's, so they provide a report and request every year.
Yes.
So moved.
Second.
Commissioner Claypool?
Yep.
Commissioner Lennon?
Yes.
Commissioner Spillier?
All right, Adrian, thank you.
Thank you.
Yes, sir. Okay, number 10 is Commissioner's Office requesting board review and decide the variance request for site 8279 Mayfield Road, Chesterland, commercial office building, owner GM Coco Development LLC. Good morning, Karina.
Good morning.
Thank you all for this opportunity to present. I appreciate it. I know as a citizen and a business owner in Geauga County, I do appreciate your time and service for our county. And I also want to mention that I do appreciate Carmela Shale from Soil and Water Conservation and Laura LaChapelle as well. I talked to her on this matter as well.
Okay.
I would like a minute of rebuttal if there is anything to be said, so I'd like to reserve that. You know, there's an adage that says that if the law is on your side, you pound the law. If the facts are on your side, you pound the facts. Both of those are on my side, so I'm going to be pounding both of that, but the adage also says that if neither of those are with you, then you pound the table, so.
So you pounding the table or you pounding the
Not,
head? No,
we
no,
might
no.
hear that, but not from me.
Just checking.
Yeah, so I know that there was a variance submitted to this board, basically to provide this board and SWCD a simple way to grant the final approval on this project in Chesterland. It's a building that has just been built, and the issue that has arisen now at this final matter is basically to close this matter as far as SW's CD is concerned. And in the alternative, after having reviewed the law even further, I have to say that the regulations really are unenforceable the way that they're written. The owner is entitled to final approval from Soil and Water Conservation District, and that SWCD cannot condition the final approval of this project in the way that they are. And it's a taint on the title of the property, and it's unconstitutional, illegal, unfair, unjust. I don't know how you want to label it, and it's anti-business as well to require that, because it's not required in the law. It's certainly not required in these facts. So, just to basically address this, the question really is, whether or not SWCD can withhold final approval and demand to encumber forever real property. They're asking for perpetual restrictive covenants on an individual's right to own property. And the law is this: the state of Ohio has legislation in place that simply says that the county, through its agent, which would be SWCD, may inspect, it uses that word, may inspect a property upon agreement of the owner. That's what Ohio law says. That's not what they're asking. They're asking for much, much more, and it is not supported by Ohio law. The easy way, the simple way to grant the final approval in this situation based on the facts is that if you look at the situation, this is a single property. The regulations themselves, this is a single property. It is a hardship to require someone to give up their rights in property. There's no other way to look at that. In exchange for nothing, in exchange for absolutely nothing. And if we look at the property itself, it is a unique property. It has a tremendous amount of frontage, and it is zoned both commercial and residential because of the nature of the property itself. The owners did not create that. That's simply the way it is. And for those reasons, if you wanted to look under the variance, then you could say that it would qualify for that as well. So I've explained why the law supports our position for final approval. I've explained why the facts support our request for final approval and closing up this matter. And just to kind of rehash what SWCD is looking for, they want on the title of the property, they want to know who the owner is. Well, that's pretty evident because it's a single parcel. That's who the owner is. That's who's in charge of this. They want to know what the maintenance schedule is, but they already know that. It's already been filed. It's already in their file. They already know what the maintenance schedule is with respect to this. They want to be able to enter, have egress and ingress on the property forever. And that's not required by Ohio law. And they're basically restating the last requirement of Ohio law and want that to encumber the property as well. And all of this, I believe, is unsupported by Ohio law. I believe it's unconstitutional to require someone to give up their rights without proper due process. And, as long as we live in a free country where your mom and pop business owners are not having their constitutional rights stripped away, and as long as the law is followed, then I think that final approval can be issued today. The SWCD is not authorized to enter the property without the owner's agreement, and the owners reserve all claims and defenses, whether asserted here in my letter or to be raised in the future. Thank you.
Board, if I may, just briefly, and I think it would be obviously important to hear from Carmel and Shale from Soil and Water as well. The purpose of today's proceedings is to determine a variance, to determine whether a variance would be appropriate. And I believe, I don't know if you've all had a chance to review the information that I've sent you. Just to review, the 3 items that you have to consider in determining whether to grant a variance are set forth in section 8.02 of the soil and water regs. The first is that exceptional topographic or other physical conditions exist that are peculiar to the particular parcel of land. We don't have any issues in this case with regard to that. With regard to the second item, the peculiar condition at issue did not result from previous actions by the owner. That does not appear to apply in this case as well, and obviously it's up to the board to determine that issue ultimately. And the third item, that a literal interpretation of these regulations would deprive the owner of rights enjoyed by other property owners, and that's up to the board to determine as well. it seems, in my opinion, that maybe the request that we're dealing with here may not necessarily be appropriate for a variance under the circumstances, but again, it's up to the board to determine. And the issue that Ms. Coca-Fulton has raised, among other issues, one of which is the constitutionality of these regs, that is outside the scope, I believe, of this variance request. That's, if she wants to challenge that in another forum, that's up to her. She has the ability to do so, but I think for purposes of this proceeding, again, just to let the board, just remind the board, we're here for a variance request, and of course, we have the regulations that are in place that we have to follow in determining that. And we have those 3 items.
Okay.
Yeah, good. Carmella?
Sorry, so the variance request, as we have in the, in our regulations, the county commissioners adopted in September of 2017, there was an amendment, and the commissioners adopted it in September of this past year. As was reiterated, there is a requirement to submit a copy of the long-term maintenance and inspection agreement, which basically identifies that the owner of record is responsible for long-term maintenance. That owner of record can change. It's not always going to be who is currently owning it at the time of construction. Also, it identifies for the owner and all subsequent owners what the maintenance and maintenance responsibilities are for that property or for that stormwater basin. And that's what we're talking about, is the stormwater basin here. So it was all about the stormwater basin. And then identifies that Soil and Water has the right to inspect given 10 days notice, prior notice before entering the property. There is no easement being granted for the operation and maintenance agreement.
And how often do you generally enter the property?
We do that once a year, and that is required of your MS4 permit, that the county is obliged to comply with the EPA, that you have to have a inspection done once a year on all these stormwater basins that get installed within the county per the permit that is required.
And if you don't get permission to enter the property, what happens?
Then we would have to come to the commissioners, go to violation, go to the prosecutor, and legal action taken to get access. The purpose of the basin, stormwater basin, and the construction of that is not for, it's for public protection. It's not just for her property, but it's for all downstream landowners and within the drainage area. It is different than things that are just on her property for their need. It's not just for the construction, it's for the construction that occurred and the excessive drainage that would leave the property.
And again,
So it's benefiting other property owners downstream.
And again, who installed the basin?
The owner's representative, the contractor, whoever they have contracted with to install it. So they did meet all the requirements for construction as set forth in the regulations. Up until this, the last step we do is to make sure we have these final documents in place. And the purpose is to protect kind of a disclosure that further subsequent owners know that there is a basin on this property. This is what the purpose is, this is what your maintenance responsibilities will be. And we will notify you and inspect it once a year just to make sure everything looks like it's working and operationally correct.
And is there an option available if Ms. Coca-Fulton's client does not want to go with the standard declaration of restrictive covenants document?
Yes, one of the, I don't know if that's we could consider a modification being, we would accept we would call it an operation and maintenance agreement. Have all the same pieces that I explained that need to be in the document, but it would need to be recorded so that there is very clear definition on what those responsibilities are for subsequent landowners. But we could call it a different document, it doesn't have to be a declaration.
Let me ask you a question, because I've heard this a number of times, and I've been struggling with this, and Carmella, you know, because I've spent, how much time do we spend on the phone talking?
What is it?
Quite a bit, and I spent quite a bit of time talking to Katerina, Ms. Coca, and I reached out to the prosecutor's office on a number of occasions. So I'm trying to, you know, it's very seldom that commissioners have a constitutional question that comes before us. We raise our hand, we swear an oath to defend the Constitution. I think that the Constitution is very important. It was set up to protect people's property rights. And while it may be inconvenient for government to take those property rights, government doesn't have a right to do that. The Constitution changed the government. That's the intent of it. And we have to consider that. Laura, you made a couple of statements, and I'm looking for you. I'm not an attorney, and so I need to process this, and I need an attorney's opinion on it, because I tend to lean toward Ms. Coca's argument that in the audience doesn't have her whole argument, which is in the letter that was sent to us. But because I don't have a legal argument to oppose that, I have the Constitution, and I understand the Constitution. And so there's an exceptional, the first variance obligation or right that we have is a geographic or physical condition that exists as peculiar to the property. There is something peculiar to this property, and that is part of it's residential and part of it's commercial. If I, as a landowner, put a retention pond on my property as a private citizen, I'm not obligated to file this stuff with the, as I understand it. Is that correct, Carol?
Because you would not have been required to do it, because
Right.
it didn't meet the criteria.
But at the end of the day, if I'm a private citizen and I put a pond in, I'm not required to file anything on my deed. And by the way, it is a big deal that government forces you to modify your deed. That is a big deal. And it is a hardship for those who believe in the Constitution, believe in private property rights, and so on and so forth. And
And you're not really modifying the deed per se, you're just simply filing an agreement in the chain of title to
I get
let
it.
subsequent property owners know that
But you're
that
being
is there.
forced, most agreements, you agree to sign to. If you're forced to agree to something, and government is forcing you to agree to it, I don't know, I'm a little uncomfortable with being forced into an agreement. Because what option does Ms. Coca have? None. The approval is being withheld unless she complies. I can tell you some
Well,
companies, hang on.
Sure.
And so there is something particular on the property in that the retention pond exists on private property, not on commercial property. That's kind of weird. It's a little bit in the zone of it's peculiar to this piece of property. And
It
so,
happens on other residential properties.
all right,
Many
but again, the
subdivisions have it on private
exception, I
property.
think there's an exception on private property, but I could
No,
be wrong
there's
because
not.
I don't know.
There is no exception. In any subdivision that gets built in the county, there are basins on private property.
That's not what the regulations say. The regulations specifically allow for residential property, and that's in section 4.02 of their own regulations, indicates that residential properties do not need to file anything against the title of the property.
If it's
So
just a
there's-
single residential property.
And it is
Right.
a single residential property, and these are two separate requirements. One if you're commercial, and the other is if you're not. And it is a big deal, and I have to just, indicate again that anything that's being required here by these regulations are actually way broader in scope than what the Ohio law requires. If you look at what Ohio law says, it says that they may enter the property upon agreement of the owner. That's pretty clear. And it is being conditioned on whether or not, final approval of this matter is being conditioned on whether or not the property owners, which happen to be, an immigrant and his wife who's a daughter of two immigrants. They live and work in Geauga County. They're citizens just like everyone else. To say that that's somehow fair to take away their rights is, I think, a total miscarriage of justice. But looking at what, what was said about section, 8.02, the variance, what the requirements are, this is an exceptional topographical and other physical conditions exist. They are peculiar. This particular parcel, this single parcel, has commercial and residential on this one single parcel. It has more frontage than private property. It's highly visible. The owner did not create any of that. That's exactly what it is. It is an absolute hardship to say that you're going to take away someone's rights, and we're not going to give you final approval until you give up those rights. You're stripping away somebody's rights. That is a hardship. That's a violation of due process. So, it is a constitutional issue. And I will say this as well, that if this does go to court, if this, the prosecutor is suggesting that it go to court, not only will the county be spending money on an unwinnable issue here, but every landowner that was coerced into forking over their rights or anyone who is, you know, they'll be knocking at your door, and any person who's ever going to be doing a future project will be armed with this case law. I don't see what the benefit for the county is in that. And this, like I said, the variance is an easy way for this county to resolve this issue, but I think there's a lot more here that could be said if it doesn't get resolved today.
So continue. I still have some questions, because I haven't resolved this in my mind. I mean, I know which way I lean, but I haven't settled it in my mind. And so, there is in the line item number 2 here, it says particularly shall result from the previous action, or that this particular condition did not result from the previous actions by the owner. And I don't believe that's the case. In other words, I think, reading what I'm reading here, we do have the latitude to create a variance. But in response to, and I've heard from Carmela and I've heard from others, that, well, we're doing this because future owners may not know that they have, I mean, I don't think, Carmela, that you would argue that Ms. Koch is withholding the inspection, that they've
No,
not cooperated. You know, everything is working fine. The whole objection seems to be the modification of their deed, and which is a perceived taking of rights. But, you know, it's my understanding, and this is more probably for Laura, that, you know, as an owner of a property, if a buyer or a seller of property, if I'm buying a piece of property, it's my duty and obligation to do due diligence on that property. That retention pond is not hidden. It's not a big secret. When you walk in there, you see this eyesore, I mean, this thing called a retention pond, and a lot of them become eyesores. And so, if that doesn't raise questions for you, and by the way, you have paperwork filed on that, the buyer has a duty to discover everything about that property. And in the course of doing that, are going to ask Ms. Coco, who's obligated under the law for full disclosure, to provide that paperwork. And so all of that is going to happen without modifying the deed. And if it doesn't happen, you know, stuff happens, it's going to happen anyway, whether it's on the deed, not on the deed. If you've got irresponsible people are going to act irresponsibly. And so I'd like to hear a response on it. I mean, I don't know that this is accomplishing anything. And by the way, this is my first awareness of this particular regulation. And so I appreciate that this came up, because now we have awareness that we've got a regulation we want to consider. But, you know, there's some questions to go back to the prosecutor's office and say, you know, what is the real constitutional basis? Is there a law that covers all of this? Is this necessary, really, to do it in this way?
Sure, and also, again, just to reiterate, I mean, we're here on a variance request, and if there are issues that are raised outside of the variance request, as we discussed with regard to the constitutionality of the regs or any other issues, those are really outside the scope of these proceedings.
This is the core of this whole thing.
Okay.
I mean, we heard this in I would call it testimony. We're not a court, but
And we're just trying to, I mean, obviously the regs that are in place are being applied, and the board is following the variance procedure that's in place. So, you know, obviously if there are going to be any modifications to the rules down the road, you know, that's another issue. But, you know, as far as the constitutionality of this, I have no issues with the regs that are in place right now. It's not unusual for somebody who challenges regs or anything else to also include an argument that, you know, they have issues with regard to, say, the constitutionality or another basis to challenge the regs. But, I mean, at this point in time, I think, you know, that it's within the board's power to decide whether to grant or not grant the variance based on the 3 criteria.
and so what is the harm? Let's say hypothetically we issued a variance. What's the harm in doing that?
Setting a precedent for all. I mean, we have on file, we know of approximately 400 basins within the county. When the EPA Phase 2 was enacted in 2003, one of the things in the law that they have provided is that the county or the community or whoever is the permittee or the MS4, Geauga County is the MS4, must provide regulations, rules to enforce that there's a long-term operation maintenance plan that is adequate to be enforced. It is up to the county to put that together. They don't tell you how to do it, they tell you that you need to do it. And what mechanism that you can follow that's going to ensure that you can effectively do that. So, we get these all the time. We have inspection and maintenance agreements for all these basins that are around the county post-2003, because it was something that we had a problem with. How do we get an owner that gets changed, a change of owner title, don't know that they have this on their property. So we've had to chase a few of these down, and it becomes a lot of, we talk about how much money the county's gonna waste. We're gonna waste a lot of money when you have how many basins that we get in a year, chasing it down, trying to get enforcement that these have to be maintained. This also sets a precedent that, we're not the standalone person in the state of Ohio doing this. Many other counties, Wayne County, Stark County, all the communities in Cuyahoga County are doing it, townships, Fairfield County. I mean, there's a whole slew of them that this is the new requirement because that's the best way and effective way to enforce it. You look at, what are we requiring of these people and how is it looking bad on us? Well, let's put the scenario out there that Coca's sell their property and then a new property owner buys it. There's a lot of ponds on a lot of properties in Geauga County. Not all of them are for stormwater purposes. Some are just aesthetically there for aesthetic purposes. So the owner decides, I don't want this, I'm gonna fill it in. We end up going out there, we find it's gone. We have to come to the commissioners, we gotta chase this down, go to the prosecutor, get legal proceedings to get them to repair it. Now that owner comes to us and say, why is it that I paid to have this filled in, now I have to pay to get it rebuilt, and I knew nothing about this, but this was a requirement of your regulations to have this pond put in the first place. Why was I not aware of that? So, in my opinion, it does make the county a black eye or look bad that you had no mechanism in place to ensure that those subsequent owners knew that this was in place, because this was a requirement that was for the protection of many residents in the area, not just the land.
And so have you had that occur? If people fill in retention ponds?
Yeah, we have.
Okay, and you have the deed restriction, so it hasn't prevented it?
No, we have not. These were for old ones that didn't have the deed restriction.
Because I was going to say, there's
These are
probably,
the
I
ones
mean,
that were-
if the EPA is requiring in the MSF4 agreement that there be retention, that there's a plan. The plan doesn't have to be modifying the deed. The plan could be something else, right?
It could be other things, but this is what is most effective in ensuring that this doesn't happen.
And explain to me how it's effective and how it
It's
stops it.
effective. It's a full disclosure. It's making sure it's very clear, black and white, of what's required. We're not altering their deed, we're attaching an agreement to the deed.
I think that's, a nice way to try and present it, but the truth of the matter is, you're changing the title. You're requiring something to be recorded against the title, and what was specifically requested was, and I'll read it verbatim, it says, legally recorded copy of declaration of restrictive covenants filed with the Geauga County's Recorder's Office. Okay? That's pretty clear that they want to affect the title of the property. And that is taking away a person's right to own their property free and clear. Ohio law in section 3.307.79D specifically says, the Board of County Commissioners may, upon identification to the owner, enter any land upon obtaining agreement, end quote. That is very clear. It does not say to take away an owner's rights or to require that the rights be taken away. Going to your issue of notice and bulldozing, if people want to break the law, they break the law. There's a lot of criminals out there that I'm sure that they knew what they were doing was illegal. They're going to break the law. Ohio has a procedure in place. They also have laws in place indicating that that's not allowable behavior. If a person breaks Ohio law, then they should stand and go through the proper judicial or proper procedure in order to have that issue dealt with. That's not the case here. These are law-abiding people. They have done everything that was asked of them. And they're still being penalized by being asked for their rights in property. And maybe it's not a big deal to other people, but it is to these people. And the Ohio law supports their position. It's very clear that this is not required. And so final approval of the site needs to be issued. And whether or not we're talking about the regulations or not, the backdrop is what Ohio law says. It's very clear. There's been several prosecutors, I guess, who have looked at this. No one has indicated any law that says the otherwise. You can't take somebody's rights without due process. It is a hardship. This is the easy way to deal with it, to enter a variance for this particular property. If you want precedent, if we go to court with this, that's gonna be precedent that you're not gonna like, because that's gonna be much stronger than granting a variance today.
And so, and Lori, I see you're nodding your head sideways, so you're obviously disagreeing with something. I'd like to hear what your comment is on that.
And as I indicated before, again, any attacks with regard to the constitutionality of these regs are outside the scope of these proceedings. I feel we're here on a variance request, and the board needs to look at the three criteria that are contained in section 8.02, and Carmella can comment on those specific items if the board feels that would be helpful. I think it's pretty straightforward today as far as the issue is concerned, and obviously Ms. Coca-Fulton and her clients are free to, if they want to challenge it in with the regs or the law in a different form, they're free to do so, just as anybody would be.
Well, the three variance conditions or specifications to consider, the exceptional topographic or other physical conditions that exist are peculiar to the particular parcel of land. We don't feel there is anything that's exceptionally topographic or physically about this property as it exists for getting this inspection and maintenance agreement. That this peculiar condition did not result from previous actions by the owner.
Is that what
That's,
that?
pardon me?
Is that requirement met?
No, they did not meet that, and literal interpretation of the regulations would deprive the owner of rights enjoyed by other property owners. There are other property owners that have the same thing, so this is nothing specific or different.
Well, I mean, there is an argument to be made that we are depriving them of rights not due to other property owners. Property owners that don't have retention ponds don't have their deed encumbered by a covenant of a restrictive covenant. And so we are depriving them of some rights, and we're doing that without due process, as was said, and that's a difficult concept for some to understand. And it's without compensation. And so if we are taking an easement, or we ask for an easement, and we approve it, we pay for it. That gives a right for government to enter onto a piece of property.
Yeah, and it's not an easement though, it's just an agreement.
What's that?
It's not an easement, it's just an agreement.
No, I understand that, but we're forcing them into an agreement. We're forcing an agreement into their deed, which is a taking of a part of the bundle of rights. There's a bundle of rights that come with property, you guys understand that. And so we're taking one of those rights, that is free and clear, unencumbered access or be able to control your property. We're modifying that. Now, in a minor way, I'll grant you, and again, while I'm sounding like I've made up my mind on this, this is a complicated thing. I tend to want to side with citizens over government. You know, because government always makes it easy in itself. You know, it's easy for government to take control of stuff. But, and it's harder for the government to work in creative ways to allow free liberty, to allow people to use their property in free ways. And we don't like to do that because it's too hard. It makes our lives complicated from a government perspective. So, I mean, I've got mixed emotions over this. But if I enter into that complication of the zoning requirement and or the private property versus commercial property, I don't know how that happens. I mean, how part of it is zoned commercial and how part of it's zoned private, because that just complicates this. But the retention pond is on a private piece of property. Private piece of property is, if it's my property, I'm not obligated to tell anybody or to file the deed. That pond is on a private piece of property. That is peculiar to this property, and I think is the window into allowing us to create a variance in this situation. And I would suggest maybe we step back after this is over with and look at these regs and see if the argument in terms of constitutionality, I think, holds. But But that, I mean, that is harm being created also, which is depriving owner rights enjoyed by other private property. So I can, again, I see a window to be able to create the variance if we choose to.
If I might,
Anyway.
and the regulations, the owner concern here, you know, when they elected to do the project that they do, you know, these regulations were in effect at the time, you know, these rules, everything that was there was fully disclosed, and this was the requirements before they elected to do the project they proceeded with too.
Do you put those regulations out ahead of time, give
They
notification that they're going
contact, yeah, the engineers will contact us and ask us, they are available online
to? So
on our
before entering
website.
into this
Yeah, they know
project,
what's required.
Yeah.
Yes. And, you know, I just wanted to go on record that the Soil and Water Board had met, and the recommendation we are recommending to the commissioners is that we would amend it, we would accept the variance amended with modification, being changing the title of that document, that it won't be a declaration of restrictive covenants. We will accept it as being an operation maintenance agreement, but the specific details that have to be in there would still have to be in there and then be recorded.
Have you discussed that with Katrina?
I personally have
No.
not.
Are you aware of that?
I spoke with Laura yesterday, and she had mentioned that, and, again, it's becoming an issue of principle, because I'm looking at what the law says, and the law does not require that. That being said, you know, as part of the file, as part of the application, the surveyor, the engineers, everyone who's involved in this very costly process of creating this stormwater retention basin.
Mm-hmm.
I mean, tens of thousands of dollars. If I had to guess, I don't even know, but if I had to
Yeah.
guess, you're probably close to $100,000.
Yeah.
Okay? So you're looking at creating this for the benefit of the community on a private individual's property. Fine, we understand. And I know that they've had lots of conversations, the owners had lots of conversations with SWCD to discuss like why and what are the ramifications and these sort of things. But if you look at what the law says of Ohio, and you look at what they're requesting, it's inconsistent. The engineer, the surveyor, they provided this. It's on file with this property, with this project. It's already in the possession of SWCD. They know what the maintenance schedule is, they know what's required. Everybody knows what's required. You talk about transferring property. Yes, it will hinder the transfer of property if you have a mucked up title. And there's no other way to say that. You're taking away a person's rights in having a clear and free title if you're asking them to record something against it. So how do people know that it's there? Well, first of all, you're definitely bound by Ohio law, and it says that if there's stormwater basins on your property, you have to abide by Ohio law.
And sorry to interrupt, but where would you suggest recording that then? If it's not on the deed, where would you suggest recording that?
I don't think you need to record it. There's no requirement in Ohio law that says you have to record anything. That's something that was invented here, okay? And people are doing it because I don't know why, but I'm telling you, Ohio law does not require it. If our legislatures thought that that was something that needed to be done, they would have put it in the procedure in Ohio law that says, and by the way, the property owners that have this on their property should record something to affect their interest in the property. It's not there. We're creating something that's not there. It's more restrictive than what Ohio law says. Now, if you're talking about notice, it's on file with Soil and Water. If you're trying to sell the property, first of all, any buyer would do due diligence. Whether it's residential or commercial, I don't care. You have to disclose things, otherwise you're opening yourself up to a potential lawsuit. So you're bound by Ohio law on that. You're bound by, and first of all, it is obvious. I mean, it's absolutely obvious. It's not hidden. You can see it. There's nothing obscuring it. It's very clear that it's a stormwater retention basin. Everyone would know that. You look at it, you can tell that that's what it is. So it's very obvious. If you're ever talking about transferring property, it's part of the process. You have to make disclosures. It's part of doing due diligence when you're selling property. You don't just, I have never met somebody who randomly buys something without having any kind of inquiry into the real property ever. And I've seen a lot of different transactions, creative ones even. everybody always wants to know what's going on with the parcel of property.
Mhm.
It's obvious, it's on record, it's already on the file, they know what the maintenance schedule is.
But it, just a, you know, I'm no expert on deeds, but I thought that was really the purpose of a deed, is to keep records of unique things on that property, whether, you know, I don't know if you want to call this restrictive or not. I don't think this forum is we're going to argue the constitutionality today. You know, that's not what we're here to do, but, and I'm kind of torn because I tend to lean towards less government, you know, less restriction. Obviously, the EPA, you know, coming in and putting restrictions, but in this case, you know, I'm kind of torn here a little bit. My understanding of a deed is the avenue or the tool to use to keep record of certain things about that property, whether unique or not.
It's really the chain of title. In other words, anything that's recorded with the recorder's office with regard to that property.
Mhm.
So the deed is obviously already of record, and Ms. Shale is proposing that an agreement be filed, which would indicate, okay, this is what the soil and water is gonna do, this is what the property owner is gonna do. Oh, and incidentally, this is binding on successors and assigns of the property, so anybody who buys the property after knows, okay, I gotta, you know, this is binding on me, I have to do these things, they have to do those things, so everybody's on the same page.
Mhm.
And again, that's not required by
So-
Ohio law.
okay.
I mean, I keep going back to that, but it's not required, but that's something that's like more restrictive here. And what you're
That's
saying is, I'm
that's-
asking you, in other words, if I were to come to you and say, I want you to give up your property interest,
Mhm.
because otherwise I won't give you final approval.
Right.
And in exchange for that, I'm not giving you anything other than the final approval, which you've already earned because you've gone through the whole process of creating what you had to create.
Right.
Then on top of that, that means that what you own is gonna be forever changed, irrespective, because now you agreed to it, irrespective if the laws ever change, irrespective of whether it's required or not, you're agreeing to give up your rights. But is it really an agreement? I mean, that's my issue here, it's really not.
Well, the argument of it is an agreement or not, are you being forced into it or not? You know,
Exactly.
I kind of look at that as,
That's,
I don't know, this might be a bad analogy, but when you go to get your driver's license, that's kind of agreement, right? You've
is.
made this choice, you're
It
going,
is.
and you're gonna
And
live
if it-
by those,
if it was
Yeah.
required by the law,
right,
then
right,
I wouldn't be here
right,
today.
right.
It is not required by Ohio law.
Under ORC 30779, which is a statute that Ms. Coca-Fulton keeps referring to, it specifically says that the Board of County Commissioners may adopt, amend, and rescind rules establishing technically feasible and economically reasonable standards to achieve a level of management and conservation practices, blah, 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 blah. And there's a procedure, as the board knows, there's a procedure in place when the board does adopt these rules. Obviously, they have to have a public hearing of not fewer than 2 regular sessions. It's got to be published once a week for 2 weeks. That gives the public an opportunity to comment on the substance of the rules. Today is a variance proceeding,
Mhm.
and we have to, we are required under section 802 of the county regs to address the criteria that must be addressed when the board looks at whether a variance should be granted or not granted. And again, I guess at this point in time, if Ms. Coca-Fulton wants to challenge the regs, she's free to do so, but we're really here just
Right.
for.
Let me ask you real quick, and if we can agree or not, with the modifications that were suggested by Carmella, have you been able to review that modification? I think I asked, but I mean, have you seen those modifications? No.
I haven't seen
I mean, 'cause-
anything, but I mean, if it's,
Because if not, I would just say, if you want to look at those modifications, my feeling is, and we can agree to go with those modifications today. If not, my feeling is deny the variance because of the threat of legal action. You know, I just would say that, I mean, it doesn't mean I don't agree with what you're doing, but I think if we can't come to terms on that modification today, then it sounds like you've already decided, under the threat of legal action, my feeling is to deny it, and unless there's unless we can agree to that
I
modification.
have a copy of the modification with me, but.
Yeah. I don't know if you want to read
I
it.
get it.
Did you want to take 5 minutes in the hall and discuss it between you?
I mean, it's probably, and you would want this modification to be recorded
Yes,
against the title of the property?
recorded.
Right, like, in other words, is something like this recorded in general for Geauga County?
Mhm. What are you asking?
Is there anything like this on record for Geauga County, that in general, that any stormwater facility would be affected by these rules and regs?
Will they have their, is there anything recorded?
I'm not following what you're
Yeah.
asking.
Okay, so what I'm saying is, does this document come from any authority? What's the authority for this
That's
document?
the sample. You can come up with your own document. I mean, you can come up with.
Okay, but what's
your own
the
document.
authority for this document? What law?
30779 and the regulations
Where?
at the county.
Where does it say that?
Because
Where
the
does
board
it
has
say?
the ability to create, as I just indicated, the board
Yes.
has the authority to create rules and regulations under 30779.
And
There's a lot of-
30779 specifically indicates what is permitted as far as ingress and egress, and it does not in any part indicate that anything has to be recorded against the property.
It also doesn't go through all the other items that are in the regulations about how you do the calculations. I mean, that's the purpose of rules and regulations. We have a lot of laws in this country, but there are rules that are based to come to the end result of adhering to the law.
I
That's
understand.
what the rules are, to
But
come
this-
up with the details of how the county is going to enforce those rules. So it's
I
a mechanism of how they get from A to B.
I understand what you're saying.
Mhm.
However, what you're saying does not apply to the actual construction or regulation of water or anything, runoff, anything along those lines.
It's to ensure the stormwater basin is maintained properly in the way we feel it's best to maintain and operate and manage it.
But it's not authorized under the law. It just simply isn't there, and so that, and I have a fundamental problem with that at this point, because it does not indicate that under the administrative rules. It doesn't say that anywhere.
So the modification to the deed that we're talking about, I'm a little confused about this whole deed thing. And so if the objective is to make people aware that there's a plan that they need to go look at soil and water, can there be a little stamp in there that says, note, go see soil and water, you have an obligation?
A stamp where,
In the deed. And so in the deed, you put a note that says, there's a retention
That might
pond,
look
go
up the
see.
deed.
Go see, no, I don't know what it is we're talking about in terms of the actual modification. So the modification is the
I
actual
don't know if you
agreement.
can actually put that, that's something on the
And
deed.
so-
Again, we're going to that, back to the deed thing. I mean, the whole purpose of change of title is to make sure there is clarity for all subsequent owners. That's the whole purpose of
No,
this.
that's what I'm asking though, Carmella. Is
But
the
having that
modification
stamp-
that you guys require,
And that's,
the modification you guys require, you're actually requiring that the agreement become
Mhm.
part of the deed.
you're still gonna have to put something on the deed. I mean,
No, that's what I'm
That's-
asking though, just to simplify. And I don't know if there's a compromise of sorts that may be possible, whereby there's notice. I mean, if at the end of the day, your concern is that people don't know that there's a retention pond and what their obligations are, putting a statement in there that says there's a retention pond and you have obligations, go see soil and water, might comply with what you're trying to accomplish. Versus embedding the agreement inside of the deed. I don't know what it is that we're embedding right now. I don't know the modification. I don't know the.
modification, we're referring to it as an agreement, not a declaration of restricted covenants.
It's just a document filed in the
And this
chain
is
of
just a
title.
template. I mean, she can come up with
So-
other documents.
so
I mean, it
what-
could be any type of document. I mean, it's, a lot of times the people we're dealing with aren't attorneys and don't know how to begin putting a document together, so we at least give them something to start with, and then they can take it to someone and edit, add it, do whatever they need to do with it. So this is just a template. This isn't a document that has to be used. There has to be a document.
Right,
that
what is
identifies
actually-
these
what is-
items.
What is the actual modification to the deed? I'm confused about that.
The title of the document.
But what is put in there? Is it a statement? Is it an
It's an
agreement?
inspection and
What's it?
maintenance agreement.
So the agreement is actually
Rather than a
embedded.
declaration of restrictive covenants.
It's just filed in the chain of title. In other words, it's filed with the recorder's office, and
Right.
anybody who searches the title, and in other words, looks at all the documents that have been filed with regard to that piece of property,
Right.
will see not only the deed, because you can't change the deed, it's already filed. We'll see that and anything else that's filed.
Right, so here's my point, and this is where I was going. So you're in fact filing in the chain of title deed, whatever you want to call it, the agreement. What if the agreement changes? Now you gotta go refile that agreement because something might change on that
That's right.
property. They might add more
And
property,
that's-
whatever the
can
case
be
is.
upon
It
agreement
might-
by both
It
both
might be
parties.
more expedient, maybe easier, rather than filing the agreement and making that part of the deed, just putting a statement in there that an agreement exists, go see Soil and Water or see the owner. Now, if the agreement changes, it makes no difference. It doesn't modify the deed. You don't have to go back and redo the deed all the time because the agreement can change outside of the deed. And I don't know if Ms. Coca would be up for that or not, but it may be another legal mechanism
Right.
to get through this.
I mean, regulations change, right? I mean, at times they change. Those, that notice on the deed will not. I mean, you're not changing the regulations with every single deed as
No.
regulations
No, no.
change, right? So,
Because whatever requirements were at the time that you put that basin in,
Right.
how it was designed,
right.
it's only applicable to when that happened
Right.
and what regulations.
And
were
you
in
keep
place
on
at that time.
file the agreements you have with all the landowners that have retention ponds.
We
And
have
so
those.
you're the store of record, if you will, or whatever.
Well, the recorder is also,
Well, the recorder only
Yeah.
records what people submit relative to
Right.
the deed.
right.
And so if in lieu of an agreement, because you can attach, I've been over there going through various records for reasons, personal reasons, but you get some of these deeds, and oh my gosh, they got, look at the Western Reserve Land Conservancy agreements that get piled into all these deeds. It really is complicated to go through. To simplify that whole process, if you just knew that an agreement existed and knew where to go get it, it would be better because that agreement could change outside of the deed. If I went over to the recorder's office now, I could just see a statement in the deed that said,
Well, that agreement can't get changed unless both parties agree to it.
okay, whatever. I mean, the
Carmella.
property may change, Coca's may decide to sell off to McDonald's next door, and the whole retention pond requirement may need to change, and, stuff happens, So, all I'm saying is, we can accomplish the same objective with a more simplified process. Rather than including the entire agreement in that deed, you agree a statement that says, an agreement exists, you've got a retention pond, hello, it's your obligation to take care of it. Enough said. That's all you need to file in the deed. The agreement itself exists with the owner, the agreement exists with Soil and Water, and so you've accomplished everything you want to accomplish because people know, and they know where to go get the agreement.
Laura, do we have to make the decision today?
You have to make a decision within 20 days, and today's the 20th
Oh.
day, so you have to make it, yes.
So, from my perspective, because this is a little bit more complicated than what would usually face, I would side with the variance in this situation. It's a one-off thing. I don't know if it has to be set as a precedent. All situations each scenario is unique in and of itself, oftentimes. And if any other citizen happens to come up with an objection, they can always come before us for a variance. That's the reason you got a variance process, right? This is the first time I've ever seen it, first time I've seen these regulations, because we've never really had a need for it. Ms. Coca was the first citizen that I can think of that was conscientious enough to read the agreements, to understand what it was, to raise it up before us, which has turned into an interesting conversation.
Well, I would assume people are reading it, yeah. But definitely brought up a good issue there. But again, I think for today's purposes, arguing the constitutionality of it, I don't know if that's, if this is our place to do that, but, make a decision today either to,
I don't think you have to make a decision on the constitutionality of
Yeah.
it, or whether it's legal or illegal. I don't think that that's the issue. I think if we're just looking at, I said, as one of the alternative arguments that I'm making here
Mhm.
today, to easily resolve this matter, to grant the variance, if you look at what the variance says, that's part, it says that there has to be a hardship.
Mhm.
And I'm demonstrating that
explain
part
the
of
hardship to me again one more time.
Well, no, that's what I'm demonstrating as a
Yeah.
hardship, is that you're taking away somebody's rights to own property.
Well,
And-
how's that though? How's
Because-
that?
Because if you own property free and clear, and now you don't anymore afterwards,
It's still free and clear.
it's not.
Why?
Because now, it's what they specifically asked for. And the reason why I filed this, and I know now they're offering something less, But what was asked for, and what I'm looking at, and I don't think that that filing anything is really ever required under the law, but what they're asking for is a legally recorded copy of a declaration of restrictive covenants, identifying the party responsible for the maintenance. Well, it's a single lot, it's the owner of the property. So that's redundant. Identifying the monthly and annual maintenance repair schedule, that's already in the file. The surveyor and engineer already demonstrated what is required. That was approved. Permitting property access, ingress and egress to Geauga SWCD personnel for inspections. And this has to run, and then the final part, so that's definitely taking away your rights to own property free and clear.
So,
You wanna have access to your property
right, so did they make?
forever.
So
Upon
did,
10 days notice.
notice,
That's not what it says here.
no,
Well, we don't write the entire thing in the inspection report.
Even said,
but it'll be in
that
the,
will be affecting the
Mhm.
title. You're giving up the right to own your property without having somebody say, I have the right to come onto your property. And it's not required under the law. And then prohibition of any alteration or modification of stormwater facilities without written approval. Again, that's covered under the law. So they're asking for a lot of redundant information to be attached to the title, really changing the title from being free and clear. So that's what I was demonstrating, is that, is it outside the scope of the law? I believe it is, because Ohio law spells out what they're supposed to do, and they're asking for much more than that, so I believe it's more burdensome and outside the scope. Is it unconstitutional? I think there's a lot of questions there that have to be raised. These are all major hardships and burdens, and that's one of the prongs that's required in order to be satisfied under the variance provision. So I have to demonstrate that, I have to
Okay.
bring those questions up.
Okay.
I don't think you have to make a decision as to whether it is or isn't, but it's part of what you should be considering, part of what you should be knowing. And as far as, the agreement is concerned, again, I don't think the property owner legally needs to agree to it. They just don't. They just simply don't. And so people make agreements all the time.
so the agreement, if not agreed upon, the final approval is not granted, correct? Is that, yeah,
I would make a different argument. I appreciate your hardship argument, and I understand it. But the argument for a variance for me is a little different, is I've tried to understand this, and this has been very complicated. I go back and forth. I'm like schizophrenic. I talk to Carmella, and I say, yeah, I agree with you. And then I talk to Ms. Coca, and no, I agree with you.
Yeah.
I go back and forth. But the argument that I see for variance in this is not the hardship is an important thing. To me, I'm a constitutional guy. It's a very important thing. But it's more the complication of this unique piece of property, which is item number 1 in our decision list, in that we have this mixed zoned situation. The pond exists on a private piece of property, and then there's a commercial piece of property in front of it. That's kind of weird and unique to this piece of property. And if I were a private landowner,
yeah.
single landowner, I wouldn't have to go through this process. That pond exists on a private piece of property, not a commercial piece of property. And so therefore, that private piece of property shouldn't be obligated to have to file the deed restrictions, and the covenant of restrictions and so forth. And so I think from that, because it's kind of weird, because Chesterland's got kind of weird zoning, and so on and so forth, I think a variance might be warranted because it's this mixed use kind of a thing, and it complicates things.
I granted that it is unique in that the actual physical pond is on private property. I mean, I
It's
don't
all
know.
one property, just make sure that's clear, it's one parcel.
Oh, okay.
Yeah, but it's
It's
zoned,
only
it's
one
zoned
parcel
differently.
that
It's zoned
has to
private.
have
Single
zoning
piece of
split in the
property.
middle.
And that's what it says, if there's a single piece of property, and then there's zoning that's commercial and zoning that's residential, and it's technically in a residential,
Like the back half of the building is or
it's
something.
technically a
yeah.
residential lot that has frontage that's zoning.
I see.
And so if
Or
you read,
frontage that is
Commercial.
Commercial.
if you
yeah.
read item 2, it says,
And
the
the
little.
owner of the property did not create that in any way, that is just
Oh, yeah.
something that's
Right.
inherent to the property
It's like your
itself.
property kind of backs into that, where that neighborhood goes, right?
Exactly.
Yeah,
So the rights, she's being held to a standard that other property owners are not being held to. because the pond exists on that residential zone property, and other residential zone properties wouldn't be obligated to do this, and yet she's being obligated to do this. And so, anyway, that's an argument for the variance. I don't, again, I could go back and forth on it, and I'm conflicted.
Can I just make a,
Yeah.
based on, really look at this, as I understand it, you have these sediment control regulations that the commissioners approved last year. And what we're talking about today is granting a variance based on those regulations. We're not talking about changing the regulations, which may be something you want to look at if there's a way you can do it. This is the variance. And when I'm just reading this for the, literally, it's like, grant a variance where there's a hardship, and then there's this important little phrase at the end, based upon all the following, and then it lists the following. And there's a very eloquent argument being made here, but I don't see that as one of the things that this is based on. In order to grant a variance, there has to be these issues that are listed right here in items 1, 2, or 3.
Right.
And I'm not hearing that.
Let me ask you something. Were these regulations just approved in 2017?
1, 2, and 3, I just made that right.
And I made that argument when I started. That we have exceptional topographical physical conditions that exist that are peculiar to the particular of land.
Or because of the split owner or
That
split
the
use of the
particular
land?
condition did not result from previous actions by the owner. That the literal, so exceptional topographical or physical conditions that exist that are
Well,
peculiar
that
to this,
means,
that are peculiar to this particle
That meets
of.
the criteria of exception.
Right, and that's what I'm saying, like, that's what we were talking about, that this particular parcel of land does have peculiar physical and topographical conditions that exist. The owner.
Well, I was focusing in on the articulate,
No, that's
case you're
fine.
making on constitutional
No,
issues.
so-
I'm like, I'm not
Are
seeing
these,
that.
Yes,
Carmela,
no,
these
that's the first
regulations,
thing.
you said these were just approved by the commissioners in
They were
2000?
amended.
In 2017?
Right, I mean. these-
Amended.
Amended, it had
Okay.
nothing to do with this.
Is that due to the
Language.
EPA,
Right,
the
making
new
su- right.
MS4 or whatever?
Making
it's
sure they're- When they update their permit every 4 years, we've
Okay.
gotta make sure the pieces, we have covered how we're gonna handle all those pieces. You know,
Okay.
they don't tell us what needs to be in our regulations, they
And
tell
those
us
can
we need to
change
get to this
all the
end.
time, right?
Right,
Yeah.
so we have to make sure our regs meet the goal of how we can enforce it and what we
Right.
feel comfortable with doing.
I,
Katerina, would you be amenable to anything being filed in the chain of title? Affidavit of fact, anything?
What's an affidavit of fact?
You're-
Define it for us.
No, just any document.
It would be a document that, again, references a particular parcel, indicates that there's certain facts that exist that affect the title of the property, and then you record it. So again, it's going back to what I'm saying is, it should not be required. The reason why I filed the variance is because I think, that this is a unique parcel of property, that a peculiar parcel of land, that's the first
But
portion.
let me ask you, I know you've gone over it a couple times here, but, so it sounds like you've got a couple different, you've got the specifics that you're arguing, but you're arguing the constitutionality of what's going on. So is it the hardship, or is it that you're just not required to do it, or all the above?
All of the above.
Yeah.
But for your purposes today, if you,
I mean, do you have a problem with this for the general public? Because this will set precedents, put it that way. This is gonna set precedents if we grant you the variance, because and I appreciate what you're doing to come in and you're super well prepared, but if we grant that variance, it will change going forward how we're gonna operate, and, right? I mean, do you have a problem with this for just the general public, or is this just your specific situation?
I think there's not an easy answer to that, because, as an attorney, I see the issues and I'm making the county aware of those issues, and it could become an issue for the county in the future. But the reason why it was brought to my attention is because I have a specific client. And this specific client, these are the facts, I've presented them today, hopefully I've pounded those facts.
Oh, yeah, I got 'em.
I've pounded the law, and, I really believe that, the easy and simple way to deal with this is with a variance.
For your specific,
And I
I mean,
I
you don't have a
really-
problem with this in general, but just your specific case?
I'm here today because of this specific case.
Okay.
And if it was zoned commercial all the way through, you wouldn't probably have an issue as far as because of the uniqueness of this lot, being that it's the way that Chesterland has this done, you wouldn't see that that would be an issue if it was commercial all the way through.
That's correct. I mean, you look at what it says and you look at what the facts are, and that's exactly correct.
Is there any residential on this property remaining where you could build residential, or is this built out? I mean, is it?
There is a house there.
Oh, there is?
Yep.
Okay.
And it's not going anywhere. That house is staying there.
Okay, and the pond is on that piece of property with the house?
Yeah.
Yeah.
Yes.
And it basically it's servicing the commercial side?
Yes.
Yeah. So potentially you could, you could break this off and sell that house?
I don't think that would ever happen.
But could you?
No.
I mean, 'cause-
I don't think that would meet even like
Zoning.
local zoning requirements for
It wouldn't?
lot size
Size
and that
and
sort
all
of
that.
thing. I think Chester would have a problem with that. I don't think we'd ever be able to get through any kind of lot split.
So you couldn't divide that and sell that off?
Not that I'm aware of, but I really haven't looked into it.
Okay.
Unless you would purchase or obtain additional property to
That's
connect to it to be able
That's
to do
correct.
that.
Or get a variance or.
That's correct.
Yeah.
You know how easy that is. You could, if you choose, I believe, Laura, you could confirm this, that the board could meet with you briefly and you could give them, answer individual questions.
Legal advice.
Yeah,
If they have any questions, I can.
but they would rather,
You know, Dave, I have a problem with that because she's representing us.
No, she's not.
no, she's not.
No,
She's
She
not.
these are
represents
the-
them.
these are the
This is
board's
their
regs.
decision.
Okay.
So she represents
She's our-
them.
These are the board's regs.
It doesn't appear that way. I'm sorry. I really didn't get that feeling. That's the first time I actually thought that, so.
No, our prosecutor
I
is
was not
Sheila
aware of
Salem.
Yeah.
And we gave our recommendation to the commissioners and their prosecutor.
Since this is their decision, she's there to make sure that they have all the legal facts they need to make a good decision.
It just didn't appear that way to me.
She's our legal counsel.
I understand now, but I didn't understand that before.
I don't think there's anything I could really add that I haven't already indicated, but.
So Laura asked a question, and that was the question that I actually asked. I didn't know the legal term, affidavit of fact. You said,
Yeah, it's just a
it's just a
document.
note or something
Yeah.
that says, hey,
Yeah.
there's an agreement. That's kind of what I was asking.
Well, it would probably need to have a little bit more information in it, but I guess that's moot, because Ms. Coca Fulton indicated that she doesn't want anything filed.
So-
in the
so-
chain of
Well, that,
So
was
if
the,
it's-
that was the question I was going to ask Ms. Coca. Just to confirm, you would object to an affidavit of fact?
Anything on file. So you would just essentially get approval, nothing goes on file.
I don't think it, first of all, it is on file with Soil and Water, but I don't think that recording something against the title of the property,
No, but I understand your
Yeah, I
argument.
have a problem
I
with
understand
that.
your argument, but you're.
I would have a problem recording anything.
Yeah, so essentially, if we grant the variance today, there will be no record on file, except for Geauga Soil and Water, correct? Right.
And the basis they could grant a variance would be if they agree that there's something, that there is a
Hardship.
exceptional topographic or
Yeah,
physical condition.
right.
That's what you have to decide.
I understand.
Or that we're depriving owner rights enjoyed by other property owners.
Exactly.
Number two. And that is a condition.
The
Because
literal-
other residential properties don't have to go through this property.
Right.
Their pond is on residential property.
The
If we
literal-
require that, that's
But
something
they didn't
that other
build a
property
commercial
owners.
building on it either.
Yeah.
What's that?
Literal interpretation of
But
regulations
residential
deprive
properties
the
didn't
owner
build a
of
commercial
rights enjoyed by other property owners. So I think that's. the-
Other commercial buildings have put ponds on their property and they have filed their.
No, yeah, but that's why this is kind of weird and unique, is because it is a split zone piece of property. If it was fully commercial, we'd be talking about something different. Now we just have a hardship discussion, or property rights, or constitutional discussion. But because we got this weird thing, it is a we're depriving rights because that's residential property. It has a pond. Other residential homeowners wouldn't be required to file. This residential owner is being required to file. That's kind of weird. And so shouldn't we issue a variance because we're requiring a residential piece of property to file?
But it's one piece of property too, so,
Commercial property.
commercial property, so that's why this is kind
But
of.
the pond is not on
It is
commercial property.
unique, it is unique, and, if you go through these bullet points in each 1, 2, and 3, and, Katrina's done a good job of making an argument on all 3, I think, but that it is peculiar condition, I think is the one that stands off the page. I don't see that it deprives the owner of rights to file something on their deed. I don't. I don't think there's any, it doesn't hurt the value of that property, it doesn't hurt you from the future selling that property.
We
But-
don't know that.
But,
We
yeah,
don't know that.
exactly,
I mean,
we
I
don't
think
know
it- I
that.
think
We don't
it
know
is.
that.
Exactly,
Yeah.
and I
But
think
we,
it
but
is if
I
we-
don't see the, I mean, everybody has deeds. I have a commercial building with deeds on it. It is just, it's a way to keep track. It is what it is, essentially.
Notice.
If it is restrictive in saying that people giving 10 days notice coming on your property, that's another argument. But that is the agreement you entered into going ahead and building a commercial building, is you have to let them have access to your facility to, if you want to build in Chesterland or build in Geauga County, or, you know. But I will agree that it is peculiar that it's residential and commercial. So the fact that the pond is on the residential piece of it makes it unique. And I think that out of these three things that we have to consider in a variance, I think that's maybe the only one that really
Might fit.
yeah.
And
I mean, that's my 2 cents, but
Sure,
yeah.
and if I would
Yeah.
just be able to say that, you know, what you're looking at is whether other property owners are enjoying free and clear properties,
Mhm.
and this property is not. And I think that's
Your
exactly where
property's
we're
still
at.
free and clear. It's still free and clear. I would argue with you about that, but it's still free and clear.
Not if you're
You can
under-
still transfer title, it's not harming the value of your property.
I think,
It's-
I think
it's-
it could potentially be a harmful part
Mm.
of the property, because what you're doing is you're giving away rights for somebody to enter and access the property
But that,
forever.
right. And that is what all businesses that are required to put these retention ponds on have to abide by if they're gonna do business in Geauga County. I mean, it's unique. I get the Ohio law, but then this is another set of regulations that Geauga County has formed to protect Geauga County soil and water, right? I mean,
So-
To meet the law and
to meet
so
the
to meet the law.
EPA law.
And, you know, maybe somebody could argue, you know, at that higher level where that law really starts, could we say that's all completely constitutional? Maybe not.
Right.
So-
But where do we fight that fight?
So technically speaking, if this residential property were split off from the commercial property, because we had that argument a little bit earlier,
Mhm.
now you've got a restrictive covenant on a residential piece of property, which wouldn't be appropriate.
Well, we have them.
And-
There are those on subdivisions.
On subdivisions, that's not residential, I mean, that's not
Yeah,
private property.
residential
but-
subdivision, there are ponds on residential subdivision parcels.
Like
I
one,
mean, not
yeah.
all of them, but there are some that happen to be on a
Mhm.
parcel that's in someone's backyard, but it's serving the whole
The whole
subdivision.
the
So
whole
that property
subdivision.
owner is affected by something
Yeah, in
that the
some
neighbor
cases-
Is
may
there a
not
restricted
be.
deed on that? or
There
a
is,
covenant,
and
whatever
that
it is?
person, in some cases, the person who owns that sublot is responsible for the maintenance and repair of it.
Even though it's
And
servicing the
sometimes
whole.
it's not, sometimes it's the homeowners association, and
Yeah.
so we have those cases.
So that's
But
kind of,
that's
that's
not-
your
But
number
that's-
3
but that's-
bullet point. Yeah, there's gonna be cases when
There
Yeah.
are cases of that.
it doesn't always apply.
But it doesn't say that we have to show that every single other residential property has these rights. It simply says that it would deprive the owner of rights enjoyed by other property owners. And we meet that test.
Well, I think we've discussed this ad nauseum, and so it's probably time for us to come to a decision. Ralph, do you know where you stand on this?
I don't know, this is where we definitely are earning our keep. It's not in a comfortable position to
I've
be
got a
in
little
either
bourbon
way.
in the back, you want to
Yeah.
go back there?
I'm drinking, I might have to start. No, I get both sides of this, it's hard,
Yeah.
it's just that this is a unique case. You know, I don't know if it necessarily would open precedents approving this in the sense that there is some just underlying other issue, you know, that I could kind of, I truly understand where she's coming from, you know, it's just, and I also understand the part is that, you know, Soil and Water wants to protect their interest, if somebody does something stupid, you know,
And protect the county.
yeah.
I
Well,
think
comply with the law
protecting you.
overall. I mean, they're trying to comply with
But I-
overall law.
But at the end of the day, I guess I look at it as they still have the legal position to enforce this regardless of whether it's on the deed or not. They still have that position. It's just, it would save, I guess, the headache of them coming in and saying the way they need to file an action because somebody's not complying, and then it takes to the prosecutor's office. And I'm not really sure. Since I've been here, we've only had like 1 or 2 of these that have come up, but then what happens with that? Do they go to the court, or do they file with the court? So, you know, then the
There
court
may
would
be lots more.
mandate,
Be prepared.
okay.
I don't know what that means. I think if we issued a variance today, it would have no impact whatsoever. First of all, it's not gonna impact all the ones that have proceeded, because those are already done, and nobody's gonna come back, you know. So often, we just go along. I mean, I'm not gonna point out today all of the things that I think are just ridiculous in zoning and in law. And I've had, what you wanna hear what I have to say about zoning, come to a zoning meeting. Because government can do it. People just don't wanna fight. They don't wanna push back, they wanna make waves. Even if it's unconstitutional, even if it's wrong, even if it's unenforceable, it makes no difference. People just don't want to have the battle and the fight. Every so often, you find a responsible person, and I'm going to put Ms. Coca in this, who happens to be smart, in this case an attorney, so she knows the law, who brings this up and allows us to have this conversation. We should have these kind of conversations to test ourselves, to make sure we're doing good law and doing good regulations and so on and so forth. At the end of the day, if we don't have to have additional regulation, why have it? I mean, we've got a law, the law is clear, you have to do X, Y, and Z.
The law is
The
not
law
clear. The law
is-
doesn't say how you get to X, Y, and Z. It
So
just
let me
says
ask-
you need to get there. It doesn't tell you how to get there.
So let me ask you though, so
That's the purpose of the regulations.
So taking away the deed issue, so if we were to approve this variance today, and next week they call in the local landscape company to bring in a bunch of dirt, you still have the legal ability to pursue this, right?
We do.
And then,
But when the question comes up, well, why did this occur from downstream landowners? Now they're being flooded. The purpose of the county having the regulations was for the protection of the downstream landowners, your constituents, that you have
Right.
elected to not put something on there to ensure that subsequent owners do know this, and that's
Are
the
you,
question
are you
like to
agreeing
answer.
to letting, even if it's not on record, are you agreeing to let the inspectors on your property?
We've never denied them. They've been inspecting the property the entire time through the construction. It is
Okay,
completed.
so you don't
It's
have a problem,
functioning.
you don't
The
have a
final
problem
was
with it
submitted.
then?
All I'm saying is, they don't have the authority to come on there unless we agree to, and we've always agreed. So I really don't see an issue moving forward.
Okay, so you don't have a problem with it?
Which that's always the case. The current owner, they've elected to do the work in the first place. I mean,
Yeah.
this wouldn't even be an issue if they didn't develop
But you
the
don't
property.
have, so you're saying you don't have a problem with them coming out and inspecting?
They've
This owner I'm not
never been
concerned with.
excluded.
No,
When they
but I
sell
mean,
it,
but
I don't know what that next owner
I
will
agree
do.
with that, but I'm saying, but
Right.
you don't have a problem with them coming out and inspecting your property. So the hardship of them coming out inspecting isn't, that's not a hardship for you then?
That's not the argument.
I don't think
Your
that,
argument
I
of
don't
hardship
think
is
that,
not
I don't think that.
Yeah, no, but
I'm not-
that was
I'm not
one
e-
of the things that was said.
I'm not equating.
Yeah.
That's not the
Oh, yeah.
hardship. No.
No,
wasn't
that's
the
one
hardship.
of them. It's one, she's made a list of
Ingress-
hardships.
Ingress and egress
Yeah.
against the title of the property forever.
Mm-hmm,
That means you're giving them a right to come onto the property forever.
right,
So you own something, but you cannot own it completely
Right.
because somebody else has a right against it.
right,
That's what the hardship is.
right,
They've never been denied,
okay.
never been denied in the past. And so, to say whether or not they, will continue to come out to inspect the property as, whatever their procedure is, I don't know anything about that.
What about if you did sell this property and the next buyer comes in and they're not so friendly? What's the, where's the teeth for,
Ohio law, again,
So
they
they-
they have every single right to go to come to you and say, this property owner is not friendly, whether it's us, somebody
Right.
else, anyone,
But
it
so-
doesn't matter. And they say,
so
this
they're allowed
person's
on the
not-
property anyway?
Yes, they can get if a judge, if they bring it before a court and the judge issues a warrant for inspection,
But we
they're
gotta
allowed
go,
to have
we
it.
gotta go to court to do it.
You do, yes,
Well, and
absolutely.
what you
And
found
that-
with the deed
Inspect.
doesn't change that. The filing of the deed does not change that
doesn't
at
change that.
all.
But it does
It's-
put the notice on.
It puts a
puts
notice.
the owner-
It doesn't change
I
it.
notice
If
the
you've got an
owner.
irresponsible
Yeah.
landowner, that guy's gonna be irresponsible regardless.
Right.
The next owner buys that property, fills in that pond, I don't care if you got a deed restriction, don't have a deed restriction, whatever, he's gonna fill in that pond. And most
Well,
people
if they
don't.
do it unknowingly too, yeah. I mean, if they're doing it
Well, then he-
purposefully or unknowingly.
Then
I
he was
guess-
irresponsible, because
Yeah.
it was his responsibility to know what he was buying, and to know that that was a retention pond, and to know what the rules and
Some
regulations.
people buy
It's his duty.
property and they fill their pond in because they don't want the pond, you know.
Mhm.
It may not be a
It wouldn't,
stormwater
it wouldn't
pond.
happen in this case
Right.
because.
No, not in your, but I'm just saying in general,
Yeah.
yeah. Well,
So, I mean, I think the line of questioning that Ralph had was a good one, in that, if somebody wanted to go fill that pond in, let's say that you sell that property, and somebody wanted to go fill it in, first of all, I don't know why they would. I mean, it's a retention pond, and it serves a
I'm
purpose.
surprised
They're-
people do.
They're gonna, well, that's true, but again, if you only say that because you have experience, right?
Right.
And
we see
so,
this all the time.
your experience tells me.
I mean,
that-
some people do want to change it, and some
You-
people, it's due to a change because
Sure,
they want
sure.
to make it look
Your,
different.
what your experience tells me is that what you file against the deed isn't gonna help you anyway. And-
Well, it does, because it tends to, what we have found is when it's on the deed, there doesn't seem to, we don't have those problems, because they know it's there. We're not fighting this uphill battle going through the courts. I mean, people can deny and shake their head no, but we've experienced this, we've been through it.
But,
And nobody, it doesn't get challenged because it is on the deed.
But
They
part-
know it's there.
Part of what tells me.
We're not trying to hide something and spring it on them at the last
Yeah,
minute.
you're not
We're
hiding
not
anything.
hiding anything either.
You're not hiding anything. That's a fallacious argument from my perspective. And I know this because you oftentimes bring us requests to take people to court because they have something and it's filed against the deed. And I'm thinking of somebody recently that put in a retention pond, and they didn't do it properly. They didn't maintain it properly. It was creating problems. You guys had to go out and talk to them, and you do that repeatedly. So what that tells me is that this filing with the deed stuff is maybe a nice thing. It gives you a warm and fuzzy that you've done something to warn future people. But at the end of the day, people are people, and they're going to do goofy things. And you being there, being responsible, and you are protecting our MS4, which is very important to all of us.
And we're very small, and we have
That's-
very few
I know you
employees and
are.
very little budget.
You
So,
know, while
all those things that we have into play, you know, we
Soil
do
Water,
it very
Soil and Water
little.
Department is a very good department. I want to be on the
I
public
mean,
record.
just that
saying
we, you know,
so.
we don't have, we can't, you know, I can't devote people to be chasing this all down for the amount of time this one case is taking.
Mhm.
You know, I don't have that kind of staff to afford to put all these people in place
Sure.
to do this. I mean, we have a hard enough time doing what we can, and we're supposed to be looking at them all once a year per our permit that we are required to do. It's pretty darn hard to get all those basins in with the small staff that we have. So we have things in place like this to make that job more manageable, because it's something we can manage and it's more efficient. So that's why, you know, that's why that's there, so that those things are less likely to happen
Yeah,
because it is.
Maybe you're absolutely right, and I'm just being stupid here. I don't see that as really helping you. I mean, you feel good that it's done something, but I don't know. Maybe it has. I don't know. I mean, I'd have you sit down and show me examples of that, but I think just people are going to be responsible. They're going to be responsible. Most people, when they buy property, I know when I buy property, I do exhaustive due diligence because I don't want to get into a piece of property and have a problem. I don't think most people do.
Talk to all the people that buy those lots and the holes. We got lots of those.
Lots of
A lot in a
holes.
hole, and they don't know why the water's coming to it. It's called gravity. But, you know, people don't always do the due diligence. We encourage everyone, we always tell people to do that, but that due diligence doesn't always happen. And when there is a requirement to do something for the protection of the public that the county required, you would think that you'd want to make sure that that due diligence isn't just making sure the homeowners make sure they, what do they call it, when you're transferring your property, making full disclosure, that it is a recorded item. This is something that's there. And that's why it's not just for that person's benefits. This is for the benefit of downstream flooding and drainage. This is not for just that person. It's for all parties that receive the drainage runoff coming off of that property.
I mean, I agree with all of the reasoning in terms of why we want to have good storm water control and the retention ponds and so on and so forth. Could you make a requirement though that they look good?
I would like to do
Some
that.
of these retention ponds, they just.
But
look
that
good.
might be going against some of the law.
Can we?
Something that truly goes against.
Can we
the
file
law.
that, can we
Clearly
file that in
goes
the
against
deed and
that.
make sure that they cut
Just
their
because you don't
cattails
like the way
down,
it
so-
looks doesn't make it.
Yeah, I mean,
It's up to your engineer to make it look nice, who'd you hire.
All
I think
right.
that, you know, this is an exceptional condition on the, particular to this parcel of land. It is a condition that was there, not created by the owner, and that it would deprive the owner of rights to own the property, really, because you're asking for them to give something up. You're asking them to give up something that other property owners don't have to give up. That would deprive the owner of rights enjoyed by other property owners.
Okay. Well, weighing everything, I tend to lean in the direction, not strongly, of agreeing to a variance. Laura, let's say that we would do that. Do we have to phrase the variance in a particular way?
No, just indicate what you're granting in general.
Okay. And if we deny, then we just deny. So I tend to lean in the direction of a variance, but I'm swayable based on the other two commissioners. I'm waiting to hear your thoughts on it. Tim, I think I know where you stand on it, so.
I mean, again, the only thing I find unique is that it is a residential and commercial, and that would be the only reason I would go along with this particular case. As far as the other arguments, I don't see those
I mean, it is unique.
factoring in. It is unique in that it is on residential property. You know, that would be the only thing I think that has kind of got me on the fence here.
I'd support both you to approve both of them.
Yeah, I would go ahead and change my decision and go ahead and grant that variance just on that case alone. But I would say I'm gonna tell you, if we do get an influx of people wanting to come in and challenge this particular thing, they're gonna have to show a unique reason why, because as far as the other arguments, I'm not so strongly in belief of those, but as it being unique, I would go ahead and grant the approval of that variance.
So I move to approve the variance.
So moved. Or second.
And the reason would be for the complicated
That it's a
zoning situation that.
Under
Right.
section 802A1.
Can you guys state the exact specification? In other words, what you're actually granting?
Why you're granting the variance, why you feel it's grantable.
That's what we were
Yeah.
just in the process of trying to do.
Yeah.
So-
I would propose that the commissioners grant a variance to the owner. To enter land if necessary, without the need to encumber the title of the real property. That Geauga Soil and Water has all of the other items in the owner's application, final plans, and records of the single lot building, and that the final approval be granted to the owner.
So, Lauren, and this is where I'm gonna, maybe we could sneak away with you in the back, because I would want to get some legal, or we can do it here openly, I don't really care. Relative to the variance request, at least in my mind, if we're issuing the variance, and Katerina, this is my thought on this, it doesn't give you license to vary from any of the requirements of the law,
No.
or a requirement to work in soil and water. You're still obligated, as though you had file against your deed, and that requirement going forward to any seller, you're obligated to tell any future home, the property seller. and so on and
The
so
only
forth. So
difference is now it will not be on
it just won't be
record.
required to be filed with the deed.
Right.
You're still obligated And the reason for that is because of the split zoning situation. It's a residential property that holds the pond versus a commercial property where the rest of it sits on.
That's what
the
you're saying
reason.
is peculiar to the record.
But I guess, I don't know if there would have to be some type of,
So you're saying essentially that the inspection and maintenance agreement does not have to be recorded with the Geauga County Recorder, I guess?
well,
That's
that's, I mean, that's
The agreement
essentially,
as you have, just not recorded.
she would still get the final approval without, I mean, that's the last thing holding it up is filing it with the county recorder, correct?
Yeah, that's
Okay,
it.
and contingent on that, I would just make a suggestion in your records to, keep on file somewhere. I don't know, that's the problem, when you don't have it on deed, 200 years from now, that this is not on record anywhere. It's in a file in the Soil and Water Office, which we don't even have anymore. That's the problem with it. That's the purpose of a deed, is for perpetuity, to keep track of all these things in one place so people can go to and easily access them. I mean, that's the purpose, I think, but in this particular case, because of it being unique, in my opinion, being on private property or on residential zoning property, that we go ahead and grant this variance. But I would suggest, somehow trying to make note of this. I don't know how you would do that.
There is
I don't,
a-
yeah.
So how do you do that? I mean, I apologize.
Yeah, that's the
the
problem.
problem.
If it's a
That's why-
retention pond on residential private property, and not all of them are filed on against the deed, right?
Yeah, it is.
Some are on the deed, some, they're, old ones are not, and those are the ones we have a lot of
But
issues
all modern, if
with.
it's a retention pond and it was recent,
Recent days, sometimes it's with the deed of record, sometimes it's on the plat, sometimes it's a homeowners association, a deed restriction, so it's varies.
but modern retention ponds are always filed, regardless,
Yeah.
residential,
Yeah.
private, whatever.
Filed across the state, you'll
Yeah.
find this is something communities across Geauga County do, Wayne County,
Because
a lot of
I could
the
go
counties
through
I've
that.
mentioned, this is what they do, because it's an effective means to ensure that responsibility is very clear.
Yeah, you helped me out with the situation where they had that drainage ditch they ran across that piece of property. It was a commercial property, it had residential property surrounding it, that we're talking about the church.
Oh, with the corner, yeah.
Yeah, the church. And so, and the drainage was a long time, I forget what the term you used was, the county engineer.
Drainage,
had-
yeah.
What was it?
A county ditch, maintenance ditch.
Yeah, and so, but there was an obligation, but that was never filed in a deed anyplace, so that we could find a
We
record
have a lot of
of.
problems with those, because these aren't filed, and this is, since 1979, the county has had these regulations in place, and there's been updates and amendments since then, and we've always required something. What that something has been has evolved because of history and experience of what has worked and what has not worked, and that's why we are here today, and the EPA has recommended these type of items to be in place.
Okay.
So we
Well-
have all these, and I mean, we've found this to be a problem. We've had some that we've had to chase down and trying to figure out. We cannot figure out what the requirement is because there is no documentation. It's either lost or who knows, in records we can't seem to find.
Yeah. I
We,
mean,
all the offices run into this, but a lot of cases like that.
There's a motion and there's a second.
I need to clarify what that motion is. That is where I am at right now. And that's what I think that Laura was trying to get across to them, is they need to specify specifically what you, are you requesting the board that you are approving and granting the variance request for the site 8279 Mayfield Road, Chesterland, commercial office building owner, GM Cocoa Development LLC, with regard to, that's what I'm-
Variance granted under section 8.02A1. I mean, when you specify the actual
And what that
basis.
Just
Yeah.
the variance procedure in general. Right, 8.02 variance.
From the requirement in the rules that a complete inspection and maintenance agreement must be provided, or must be recorded with the Geauga County Recorder.
So that's what you're granting the.
and, I mean, yeah, and regulations still apply,
You
That's
still
not,
get
I
agreed-
didn't
Yeah.
ask for regulations not to be
Yeah,
applied.
yeah.
for. with
Right, but
respect to the variance.
yeah, okay,
The same agreement will be in place, it will just not be recorded, is what you're saying.
yeah. Yes, right?
I didn't ask for that, no. I simply said that whatever is required by law that the owners have to do, that's exactly what
Right.
they will do.
But the regulations are considered part of the law.
Yes.
And so all law, Ohio
They'll-
revised
the owners will
code
follow
and
law,
local
yes.
regulations and stuff still apply. We're
Yes,
just
yes,
giving
yes.
you a variance on the recording part
Yes.
of this
That's absolutely correct.
regulation. The regulation is still considered law for effect.
Yes.
So, I'm not an attorney, I'm not trying to.
Or then we are gonna get an agreement that's not recorded, or we are.
I say that again?
Are we going to have an agreement or not? Because she kind of wavered on that that's not what I'm agreeing to, she said. Is there going to be an agreement? Even though it's not recorded, are we going to have an agreement with all the basically the same type of
It
document,
just won't be
not
what the
recorded?
recorder,
Yeah, I mean,
Is that-
Katarina clarified that because in my mind, that's what you're agreeing to.
right?
Correct.
We're just
Are
not
you okay
recording
with that?
it. All of the agreement is still stands. You're gonna comply with the soil and water and so on and so
And
on.
that's binding on successors on the signs, it just would be recorded
You
in
won't.
with the Geauga County recorder.
Not be recorded.
I would enter into an agreement that is authorized by the law. So I'm not gonna further like bind anyone or take away anyone else's rights. And that's the reason why I'm here today, is because I felt that was going beyond what the law indicated for this particular property. I don't foresee an issue with any kind of understanding between soil and water and the property owner
Mhm.
as far as what they need to do in order to accomplish their inspections. So,
Yeah, but there's an agreement. This is a little soft and feely thing, and I want to get confirmation of this because it's important, I think. And that is, we have an agreement. You have an agreement with soil and water to comply with, if they make a request, you have to approve the request to come on, inspect the retention pond, and so on and so forth. So that
Right.
And maintain it.
And so
Yes.
that is,
Yes.
the requirement on the part of putting the retention pond and being able to do your commercial part of your building and so on and so forth was that you comply with those certain rules. The only thing we're giving you a variance on today is filing that
it doesn't need
against
to
the
be
deed.
recorded.
All the other agreement still stands. You're still obligated, and I want to make sure that you say that yes, I'm in agreement with that I've agreed to that, and I'm going to be moving forward with that.
So you're moving to grant the variance request with the condition that
Yeah.
the property owner must still complete an inspection maintenance agreement.
Right.
And that the maintenance agreement, the inspection maintenance agreement does not need to be, and that the agreement shall be binding on successors and assigns, and that the agreement does not need to be recorded with the Geauga County recorder.
Like,
4.020, to make it maybe a little simpler, that she has to comply with the requirements of 4.020, except for the recording portion of it, recording the document.
okay. You're okay with the agreement, just not putting it on file, correct? I mean, I'm reading the agreement here,
That's not required for residential properties.
okay, but this
So
isn't a
that's- yeah.
residential property,
Right,
right?
it's a mixed
commercial-
use.
Commercial,
Right.
yeah. I mean, that's what it's being utilized for, is commercial, correct?
Yeah, well, part of it.
Part of it, because there's a house too.
Yeah.
Okay, but they're on one lot. It's weird.
It is very weird.
And that's the only reason I would agree to grant this, is because of the strangeness. And I know we're taking a lot of time
I know.
here, but I want to get this right, hopefully. But there are certain requirements that we're just kind of scrolling through here that need to be agreed upon for soil and water, that, as a property owner, you need to continue to maintain, stormwater pond maintenance, monthly schedules, yearly.
4.020, is that what you're looking at?
Yeah,
That is not required for residential lots, and
Okay.
they already have that from the surveyor and engineer submitted in this file as to what the maintenance and requirement is for the property.
is that on file where?
That has to be an agreement.
Yeah,
That's-
I mean-
That has to be an agreement. It's not for the engineer to tell me that this is what's gonna happen. I need that the
He
owner.
submitted it and it was
is gonna do
approved.
The owner will approve it.
No,
Owner of the property will
the-
agree
the,
to. Because the engineer, I mean,
The engineer is just putting that together
Yeah.
for the owner to agree to.
yeah,
Well, yeah, we'll look at what the engineer put together and was already submitted and approved by Soil and Water, so I don't think that that's gonna be an issue.
okay.
So this agreement that we're looking at, this is a sample.
That's just a
operation.
sample that we
Is
give
that,
people
is
that
that
we
the thing
start from.
that the county engineer's working on that hasn't been agreed to yet? I got confused.
No, it's not, it's the surveyor and engineer that was hired to do the project.
Mhm.
Okay, submitted a maintenance schedule with the final plans as built that were already submitted and on record with Soil and Water Conservation District. That's been approved, that's not at issue, that's been accepted.
We approved the as-built. We did not approve the maintenance and inspection. That is an agreement that we are waiting on. That's where we are today.
That the property owner's agreeing to the
Right.
regulations.
I don't,
and-
I'm not feeling like she is agreeing to agree to it.
No, I don't.
I'm
not
getting,
hearing that
I'm
either.
getting a very vague and
Yeah.
fuzzy.
I absolutely, the surveyor
I
and
mean,
engineer have
you're already getting
submitted-
the, no recording that we have a problem with, and we will go on record, and that's the recommendation we said to not agree to do that, but that's the only thing that I'm understanding that the commissioners are saying, we're granting a variance of the recording component.
Correct, otherwise she has to comply with all of the
All the other
requirements
requirements,
of
which is having an agreement, so that
4.02.
agreement
Oh.
needs to be on file, like you had
agree.
indicated, we'll have something, well,
No, I
I
agree
wanna
that
make
there
sure
should
we're
be
having
no
that.
recording, and I agree that whatever the surveyor and engineer prepared regarding the maintenance schedule that was provided on the final plat,
You're agreeing to the soil
I'll
and
read
water
it.
regulate districts regulations.
it was approved by them, that's what was
Okay.
listed on there, so.
It's
I-
not the
they'll
same.
stand-
not the agreement.
I don't think so, right? Is it the same? I
No.
mean, unless we can have those two documents side by side, or, the agreement itself reviewed and agreed upon,
Right.
okay? Can we
need
do
to have
that
that
today?
agreement.
So
Yeah.
let me ask you an off-the-wall question. Can we get a variance to the deadline? Can we extend that deadline a little bit so we can sort through this agreement process? No?
Yeah, you have to make a decision.
We have to
Either
make a
approve or
decision.
disapprove.
You're a
This-
hard taskmaster.
I have a cold, sorry.
Yeah, it's approved modifications or just.
Yeah.
I was under the impression that when the engineer and surveyor prepared all of this and submitted it with respect to this property, that was also approved by Soil and Water. If they have things that they would like to have added to in addition to that, I think the property owner would be amenable
Because
to
I
looking
thought
at that and seeing
your
what else.
biggest problem with this was that it was going on file on deed, and it was a detriment to your property rights, and it was a encumbrance to the future ownership, and that was the, to me,
that was the big-
that
that
was,
was the big issue.
so that we've agreed to give you a variance and that you don't have to file, it's not gonna be attached to your deed, but all the requirements are still in the same, they're in same.
Yes.
Yeah.
Okay, so we're all in agreement there.
And
I just
again,
don't think that, yes, we will follow the regulations, and I thought that they had already had done that and gone above and beyond.
Okay,
so I guess for purposes of some language, I guess you're proposing to grant the variance. Are you?
I'm at a loss. I'm looking at Laura going, help me.
Are you proposing to grant the variance with the condition, with the condition that?
it's lunchtime.
No, it's office. With the condition that, the maintenance, the property or the applicant will complete the inspection and maintenance agreement, as specified in section 4.020, and the, agreement will not have to be recorded with the Geauga County Recorder, but they'll otherwise have to comply with all requirements set
4.020.
set forth in 4.020.
And you're familiar with you're familiar with 4.020?
That's everything that they were asking
Okay,
for.
okay.
And that was one of the reasons why I thought it didn't need to be recorded, because it was affecting the title.
Right, but it won't be
It won't be
affecting
affecting
the
the
title
title.
now. But all the procedural
All the
language will.
Specifics have to be in that agreement,
Yeah.
which we do not have.
So,
at this
Laura,
point.
would it be appropriate to put a clawback clause in there that says if the agreement is not complied with, then the variance is null and void, and we'll move forward with the.
Well, it's granted on the condition that they will execute, or they will agree to execute an inspection and maintenance agreement as specified in 4.020. And otherwise, we comply with all of the requirements of 4.020, except they do not have to record it with the recorder. So if they don't comply with those conditions, then obviously that issue will have to be addressed. I mean, it is a condition.
All right. Okay, you got that?
If not, I will get it.
Would it make this a little simpler if the agreement was presented
It
to
is.
to Ms. Coe? Okay, got
She
it.
has it in her hand.
Review it,
In her
agree to,
packet
you
papers
know,
that I gave it to her.
This, okay, so then that is where I have a fundamental problem with, because 4.020 specifically talks about deeds, restrictions, restrictive covenants, designate and provide, recorded with the property, so it cannot be,
Okay.
it cannot be that.
so you don't have, so it's not only you have a problem with it being on the deed, you've got problems with the.
It's, well, what they're saying that you're granting the variance in accordance to goes back to saying that there's agreements, deed restrictions, restrictive covenants, recorded with the property of the deed, so it cannot, that cannot be what you're granting
can't-
and ungranting at
That's
the
right,
same
we
time.
can't force her into an agreement now that requires us to put it into the deed.
Right,
Which
which
is-
is
No,
what
no.
it says, we're forcing her into an agreement that's not going to be recorded.
Yeah,
That
with the
is-
condition
that
that,
condition
Correct.
is,
with the
Okay.
exception of the requirement that the agreement be filed with the Geauga County Recorder.
and the sample that I gave her earlier, she can utilize that and
Okay.
submit it to us.
I had submitted, with this originally, a letter just indicating a notice to the owner to enter the property to do their inspections pursuant to Ohio Revised Code. So I would be willing to do that right today. That's, simple, it was just simple notice to the owner, request to enter the land, agreement to enter the land pursuant to Ohio Revised Code 703.79D, administrative rules. County Board of Commissioners are duly authorized representatives of the board to enter on the land to do the inspection. That's what, I don't have a problem with that.
Just doesn't identify what those we want all the pieces of that.
All of that
on-
information.
On the agreement that is signed.
Right.
Something on a plan that the engineer has stamped and certified does not constitute the owner agreeing to it.
But it was submitted on behalf of the owner, and the application was done by the owner.
Yeah. So the variance is very vague in that, if we grant the variance, meaning what? That all, everything's gone and forgived, it doesn't, I think you still have to meet the requirements of the Geauga Soil and Water District, correct? I mean, that's what's in the agreement. We're just saying we're not gonna attach it to
The deed. which
To the
what-
deed
what
to-
she had
The owner will
Encumber
follow
your-
Ohio law.
Okay.
We'll
and
we'll
file
do
the
that.
regulations of the Geauga Soil and Water District.
And follow. I can't say that exactly because I have a problem with what,
Okay,
is that
which piece is it?
This is the section that they're actually talking about right here, and which you might be looking at where it says, 4.020.
Okay.
It talks specifically about easements, restrictions, so I can't say that I'm gonna follow that if I'm
It's a
asking
or.
for
Those are the
variance.
slashes are.
Let me see
A
that.
deed restriction, a declaration, an inspection maintenance agreement, or agreement. So it's one of those three things, and we are taking out the requirement of recording, is what you're
Right.
proposing.
But this,
We are not proposing.
Katrina's got a problem. Inspection and maintenance agreement binding the owner and all subsequent owners of lands where
Yeah.
stormwater management facilities to be constructed.
Right, and the whole part of that, which,
Mhm.
goes back to the initial paragraph, 4.02, is indicated here that just says that residential developments don't have to do that portion. It's not listed as one of the items that they have
I
to do.
understand
So
that.
that's why I was
I
asking
understand.
for the
Because
variance.
there's
And that-
another mechanism in place.
Yeah, and that's
So-
what we found unique, but
So I mean, we would agree, and like I said, I submitted with the original application, a simple letter indicating that the owner would agree to have the inspections occur as required.
and meet all of Geauga Soil and Water District
And they have,
regulations.
and they did
Okay,
that.
okay.
They're, I mean,
But
that's,
as
it's
far as
completed.
the future maintenance agreement, right, there's monthly,
She doesn't
yearly.
want to put the other, our pieces of it in there, and that's why I'm trying to get that, other agreement we have out there.
This was just about not recording it.
Well, it
Now
is,
it's
but there's
not
more
easy.
to it, there's more to it.
Yeah, there is a lot to it.
Again, I hate to hold up everybody's time here.
Exactly.
And it sounds like we're under the gun as far as the deadline goes, but, I stand on my, agreeing to, the variance as far as, but everything in place as far as Geauga Soil and Water District's agreement goes and regulations still need to be intact and met and
Just
agreed
have-
upon.
Just have to
But
have
we're
it
just
on
not gonna
a
file with the
document, all of
deed.
it on one document that the owner signs. That's
Yeah.
all we're asking.
Yeah, and can you provide that agreement, you know, print that out and, or you have it and,
I think, yeah, if you
Agree
guys
to
wanna
it.
enter that in your decision, you absolutely can.
okay,
Yeah, that's, I mean, I'm in total agreement with Tim on that, and that is, we're not trying to give you a pass on following the rules. It's just
Just following
recording the
the
rules
rules.
with the
Done.
deed.
Yep.
And so the rules have to be in place, or the decision, the resolution we're gonna make is null and void. And we'll go back to, right, you have a question?
Can I ask two questions?
sure.
First question, when the landowners took on this project, Carmelo, was this regulation in place at that time?
Yes, I did state that earlier, yep.
Okay.
Yes.
So the pond that was supposedly on this residential side, wasn't it put on there due to the expansion for the commercial?
Yes,
So it's all one parcel.
it is all one parcel. One
It's
parcel.
not changing anything.
one
So
tax-
Yeah.
I'm just
Yeah.
trying to
It is-
understand
You're right.
that
You're
the
just trying to
regs were in
complicate
place
things.
when they chose to do the
I-
improvement.
It is.
They knew that they were gonna have to record this.
It
at
was
that
a
point in
result
time.
of new construction.
Right,
Yeah.
but they knew at that point in time when they chose to do the construction that they were gonna have to record this.
Correct.
I don't know that they knew that, but I will say that that's what makes this a specific and unique situation.
Part of that due diligence
Yeah.
that all property owners usually do.
Yep.
Right.
Yeah.
The pond is part of the development, so it's always gonna, it's not, has nothing to do
Right.
with the fact that the residents
I know,
can use it.
I know, and I'm trying to, squeak through there to, you know, hopefully relieve the landowner a little bit of leniency here and, but it sounds to me that the real concern is not so much the deed, or it is a
That is-
concern,
that
it's
is-
one of the concerns, but you have throughout this agreement issues with it. So it sounds to me that us just granting you the deed restriction and not putting it on there is not solving your problem.
It's all
Or-
part of the problem.
So it's part of the problem. But again, I still believe that what Soil and Water, Geauga Soil and Water has in place is necessary, and I'm not willing to challenge those regulations today. So, I would say you are gonna either need to agree with our variance we're offering today with the deed restriction or not, and let us know that, and, because now I'm starting to kind of lean back the other way. I know it's starting, because it sounds like you don't want to agree to any of what Geauga Soil and Water has proposed. You have your set of guidelines that you have agreed that you will follow, which, and I believe you in it, but the problem is it's the next landowner and the next landowner and the next landowner that may not follow those same
We want it all
agreements.
in one document.
Yeah,
What-
yeah.
That's all I'm at.
Yeah,
It's gotta
yeah.
all be in one document. We're already giving up the thing that I really want, that we really need to have, but now we're arguing about it all being in one document. I
Right.
don't want it in, 10 different places that I have
Right.
to find out, did they do this, did they do this? No, it's gotta be all agreed to.
Because I don't
The
think,
owner
and
signs
I
off.
think Nick brings up a good point, and we are kind of, sliding under the door a little bit with the residential, not, commercial aspect of it, but really the reason the retention pond was there is because you built a commercial property, or commercial business there. And you knew those regulations going into the building of this. It wasn't, they didn't, surprise you at the end saying you've got to do all these things, I don't think. I mean, it was presented up front, right? And you were aware of those up front? Yeah.
2009, I think.
Okay, yeah, so, but if we're not going to agree to the Soil and Water's regulations and their agreement, then, I would
I'd
say
be
if we
happy
gotta
to look at their
rescind.
agreement.
Okay,
I mean, I got it today. I'd be
Okay.
happy to look at it.
okay,
But what I would say is, whatever the engineer and the surveyors put together for the actual stormwater retention basin,
okay,
I would wanna look at that too.
okay.
Well,
You can attach it to the
I mean,
agreement,
isn't
but I
that,
want them to
I
sign
thought
the
this was
agreement.
all a done deal, other than recording it at this point. And it's not, I mean, we don't have an agreement on it.
More closer moving here.
We came up with some language. I would be willing to read it and then go with any modification that we need to.
Okay, let's hear it.
The Commissioner's Office is requesting the Board approve and grant the variance request with the requirement that the property owner of Site 8279 Mayfield Road, Chesterland, will comply with Soil and Water Management District Code of Regulations 4.020 and any other applicable regulations, with the exception that the property owner will not be required to file the maintenance and inspection agreement with the Geauga County Recorder. So that leaves your maintenance inspection agreement still needing to be agreed upon between Ms. Fulton and Soil and Water, but that it's just not being recorded.
And any approvals, final approvals, which are apparently are being withheld at this point in time,
Pending until we receive that.
won't happen until the agreement is signed. And so that's the carrot and the stick, so to speak, so.
The reference to the regulations, you can just refer to it as the Geauga County Water Management and Sediment Control Regulations. In your, what you read. It's not soil and water code or anything.
Geauga County
Water Management and Sediment Control Regulations.
Water Management and Sediment Regulations. And it is 4.02 in
Oh.
parentheses
Oh.
O. That's how I have it written.
.02.
Laura, does that sum it up?
If that's what you guys wanna, if that's where you wanna go.
Come on,
That's
let
what
us
I was
have
at
that
when
one.
you
Yeah.
were, you guys,
No.
when I walked out of there, but I don't know.
So,
And just that we're on, soil and water's on record that we do not, our recommendation is just the variance approved with modification, having the document language changed to not read declaration of restrictive covenants, that it is an inspection and maintenance agreement, but it be recorded.
That's
We're
where I
going on
was.
record that that's our recommendation,
That's-
that we forwarded to the commissioners.
And how is that, I'm confused on the difference between what you just said and what the restrictive
She
covenants were.
doesn't want it to be called a restrictive covenant. We can call it
We
an
can change
inspection
that.
and maintenance agreement.
Yeah.
That was what our recommendation is, and we're not changing on that recommendation. Just
I mean, you could
future,
call it
if
whatever
somebody
you
were to-
want at this point, because
Why
it's not
did this
gonna, it's not
happen?
gonna be restrictive, it's not gonna be on the deed,
Right,
so you can call
that's
it
why
whatever.
we're.
Call it whatever you
we'll
want.
Call it something else,
Yeah.
right.
Are you okay with that?
Not our modification, she did, they.
No, you're not okay
Yeah.
with that. No.
I thought this was all about, are we gonna record it or not? And we could change the name of it, but then it started.
Well, there's
sound like there
layers
was
to
other
it.
thing.
There's
Yeah.
layers to the argument, and some of them I agree with you, but I don't think we can, again, I said, argue the constitutionality of thing and private property rights here today, but I agree with, I know, I don't, but those
I'm just-
things are in place, and we're not gonna change those today, you know?
I was just speaking
Yeah.
to Christie's motion, that she's, from what you
I
guys
see.
have said. I just wanna, as an aside to that motion, we wanna be on record that we did not, that was not a concurrence of our, that
Suggestion.
recommendation
Yes.
to the commission.
No.
That's all. I think we've already passed that over way too much, so.
Right. No, I'm with, I was.
You wanna do it one more
following-
time? We got
No.
an hour for lunch, so.
Hour and a half earlier, or older than we were when we started this.
So let me ask you just, and then we'll roll here. Logistically, does she have to sign off on something for
Yeah,
final
there has to be an
approval?
agreement, that's part of
Okay,
that 4.02.
okay. And when will that happen?
When she looks at the document, I gave her the sample
Okay.
today to
Okay.
work, I mean, she can put something else together, but.
So we can
We
make
do
a
have to have an
motion
agreement,
under the
those-
contingency that
Everything be
happens,
signed.
that's signed, that we'll move forward with that.
I believe the as-built has already been submitted by the engineer and surveyor.
Okay,
And that
okay.
is accepted.
So as long as those things fall, that is agreed upon, under that, we'll go ahead and grant the variance for,
Soil and water and the owners come to an agreement.
yeah,
Okay.
Can I ask a question?
sure.
Laura, should the motion also include the issue that the final permit will not be issued until the agreement is in place?
It's a final approval,
Yeah, the
final.
Final approval?
Yeah, the permit, they already have the permit, it's just
Signing off,
signing off on the project. The project's
like
completed.
closing it.
Closing the
Yeah, we
project.
don't need to restate that because
Because
it's,
if you don't say that, then you got your variance, but maybe I don't feel like signing the agreement and you have.
Well, that's
to-
what we were saying, yeah, the contingent
You're not
on,
gonna issue that
Yeah.
final thing until you got the agreement in place.
right.
I don't know if it, should it say that in the motion?
That's what I'm working on now.
I don't know, Laura's
I agree.
attorney, I'm
Yeah.
just asking.
And that's the thing, I don't represent Soil and Water, so,
Nick,
I mean, it's up to Carmella.
I would say if we don't get that agreement, we do not sign off. It has to be agreed upon agreement. We have to get that signed agreement.
yes,
that's.
And that should be in the
material
language.
variance or-
Yeah.
that should be in the language. Nick,
Because as we discussed, 4.020 does require a,
List of 6 different things that.
okay.
yeah, and I think you guys looked at that.
My only last question, my only last statement for you would be to reference the permanent parcel number, not just the address.
Okay.
Do you have that, Carmella?
I'm looking, I don't have it, I might not have it with me. I can't read it because I don't have any glasses. Because I'm old.
I don't think anybody listening.
No, I don't see it on there.
It's not.
We'll get through this.
We're probably gonna take an hour recess for lunch. and then we'll be back.
Let's order some pizza. Yeah.
I know,
No,
unfortunately,
no,
I do
we
have
wanna
another
try and get this
appointment,
right, you know, I mean, hopefully. I don't want it to be a burden on anybody.
This is a tough one. I don't know if there's a right decision, so there's a decision.
Can you provide
I'm
that?
wavering right now, so make it quick.
So, can we still move forward without that parcel number? And that'll be added, or,
So the variance is contingent upon the property owner agreeing to the maintenance inspection agreement.
to Soil and Water's agreement.
The
Agreeing to it.
issuance of the final, what is it called again?
Closing the site, closing the project. Final closeout.
To the maintenance. I'm sorry.
All right.
So the variance is contingent upon the property owner agreeing to the maintenance and inspection agreement that will then close the project. That is the second line in addition to the above motion that I read. So we have, the Commissioner's Office is requesting the board approve and grant the variance request with the requirement that the property owner, site 8279 Mayfield Road, Chesterland, and I'm going to put, in parentheses, parcel number, and I will get that parcel number and include that in the motion, when it's completed. Will comply with Geauga County Water Management and Sediment Control Regulations 4.020 with the exception, and any other applicable regulations, with the exception that the property owner will not be required to file the maintenance and inspection agreement with the Geauga County Recorder. This variance is contingent upon the property owner agreeing to the soil and water maintenance and inspection agreement that will then close the project.
So that the project can be closed.
Mhm.
And just to be clear, should the agreement not be signed, are we gonna give a deadline or something in there? Because at some point in time, this resolution would be null and void should the agreement not happen.
Should, what do you think, within 30 days, or?
There's nothing in here under 8279 Mayfield.
I know, that's what I'm finding too.
8299 Mayfield, there's a parcel, I don't know if that's the one.
Type in the last name.
I did.
That's
I put in Geauga, it came up
I did put
8299
Coca.
Mayfield Road. Maybe that's the
Right,
parcel.
so
That's the
But it's not
property
what's
owners.
referenced here in this letter, it says 8279.
That's
Thanks,
what's on the
Nick.
inspection report. I don't know.
Yeah, thanks a lot, Nick.
So you have a single parcel with two addresses, is that?
No, we're trying to figure out where we can get that number.
I mean,
And there goes.
it's 3.53 acres, Geauga Development LLC, 8299 Road. And that's parcel 11028200. I'm sorry, yeah, 8299 Mayfield Road, Geauga Development, and it's parcel 11-028200, and it's 3.53 acres. So maybe that's it.
But didn't it say 827?
Well, that's what the
Supposed to be
letter says.
829.
The site location is 8279, so that,
Here's the site inspection report from November of 2017.
But it could be that when the orders came in, they put the wrong.
Let's see here. It's 8279 Mayfield. Here's the parcel number.
Oh, there it is.
Parcel numbers.
Yeah,
it?
11, 24, 2700.
what am I supposed to go with?
That's
So it would be, it needs to be
What I'm
8299.
coming up with for 8299, it says here there's a,
It is 8299, looking at the map.
yeah, there's 1,833 square foot dwelling, and then it says property class, office building, 1 and 2 stories.
I actually really do need to go, so
8299.
have another appointment.
The parcel is 11 028 200.
Yeah, that's what.
Okay, so I'm going to make this 8299 Mayfield Road.
Yes.
Parcel number 11-028200. And, agreeing to the soil and water maintenance and inspection agreement that will then allow the project to be closed.
Yes,
Is that good?
I unfortunately need to go, so do you need me for anything else?
I just want to make sure. Tim's going. I just have to have a vote. I don't have a
Okay.
vote yet, so.
And you'll have to next, so I will just briefly. I'll look at it, yeah, that's what I said, I'll definitely take a look at it. I saw it today for the
Now,
first
the only other
time.
thing that was in question that was not clarified was a time limit.
Thank you.
Did you want to put,
Thank you.
did you want to put a time limit on it?
Sorry about that. Sorry about that. Yeah, I don't think we want to leave it up to the end. It could take 5 years.
30 days is, I would want to go like 30 days, less than 30 days, so 30 or less.
We have 11-028200. Yep, that's what we got.
Thank you, Nick.
Thank you, Nick. He has sublot 25 here. So, do you want me to add to that, with,
I think the only thing that, the information that I had, and that's what was on the variance, which was the site inspection report, so I don't know if those are
Okay.
consistent. So maybe figure out if those are, I don't know what the site inspection report is about then.
I think the owner gave us the wrong address to begin with. Because
Doubt
we
it.
get we get the information from the owner application.
Okay, so.
Okay.
I doubt that they gave you the wrong address, so I think there might be some discrepancy, so definitely want to check the
Okay.
site report.
We'll make sure that's.
so, I just want to clarify before she walks out the door that you are agreeing to have this completed within 30 days. To add that into the motion.
Is that reasonable? Is that reasonable to you, Ms. Coca? 30
Sure.
days?
Sure.
Yes, no?
Going once?
Okay, that sounds fine.
Yeah.
Thank you.
Okay. Okay.
Yes, okay,
Okay.
thank you.
Okay.
Thank you. Apologize.
So I had, the motion was made by Mr. Claypool and it was seconded by Commissioner Lennon. Does that still hold?
Yes.
Commissioner Claypool?
Yes.
Commissioner Lennon?
Yes.
Commissioner Spudler?
Aye.
Okay.
Would you mind just reading that to me?
This is what they just approved.
Yes.
The Commissioner's
Yes.
Office is requesting the board approve and grant the variance request. I can't even read my own chicken scratch. With the requirement that the property owner of Site 8299 Mayfield Road, Chesterland, parcel number 11-028200, will comply with Geauga County water management and sediment control regulations 4.020 and any other applicable regulations, with the exception that the property owner will not be required to file the maintenance and inspection agreement with the Geauga County Recorder. This variance is contingent upon the property owner agreeing to the soil and water maintenance and inspection agreement that will then allow the project to be closed and must be completed within 30 days.
Agreed. They're agreeing, they don't agree with it, then they don't.
So it has to be, it has to be completed within 30 days. So
Right.
she
Well,
has to-
what if she doesn't agree to it?
That's what I'm saying, is it agreeing to it, well, if she
It's contingent
Well,
upon.
this variance is contingent.
Of
The
her
Yeah,
variance
if she doesn't
is
agree to it, then
contingent
yeah,
upon
that's
her
right.
Okay.
agreeing to that agreement.
I'm getting. Is this like a free education or what? This is like amazing.
free and lunch.
Yeah.
So if it's not completed, if she doesn't agree to the agreement and it's not completed within 30 days,
Okay.
then I guess we bring it back
Nobody
and
can
we
accuse us
deny
of rubber
it.
stamping. No, we
Never.
do not rubber stamp that one.
Okay, and now I have to go back to my agenda.
Okay. I don't know.
There's that easy button.
I don't think that satisfies her.
Well, she sure can say she wasn't heard.
Yeah, right.
So going back to the agenda, number 11 and 12 is
Yeah.
county auditors requesting the board accept, execute, and file the monthly statement of county finances filed by the county auditor for the months of June through December 2017 pursuant to ORC 319.15. And the county treasurer is requesting the board accept, execute, and file the monthly statement of county finances filed by the county treasurer for the months of June through December 2017 pursuant to ORC 319.15. And you just have to sign these before you guys leave today.
Thank you.
So with that, for 11 and 12, do I have a motion?
No. Second.
Commissioner Claypool?
Yes.
Commissioner Lennon?
Yes.
Commissioner Spudler?
Thanks for being patient. Hey guys. Yeah. Did you learn anything?
I did,
No,
actually,
not-
very interesting.
Stay away from here.
I wanted to explain, it says in this, I'm requesting that you approve this, our grant that got increased by $35,000. I did want to explain that when I submitted this grant, they told us to submit it at a decrease back in June, so they said many programs might be cut. If you don't hear from us specifically that you did not get cut, we did not hear from them specifically, so they are just essentially increasing it to what we usually receive. So not an increase to do anything additional, just an increase to put us back at 100%.
Okay.
Okay?
Good.
But it's an increase from the original.
Increase from the
agreement.
original from June.
Okay. So the Common Police Court Adult Probation is requesting the board approve and execute the addendum to the Community-Based Corrections Program 408 Subsidy Grant Agreement, increasing the grant award $35,975 for fiscal year 2018, bringing the total grant amount to $179,874 with a local match.
Second.
Commissioner Claypool?
Yep.
Commissioner
Yes.
Lennon? Commissioner Spudler?
Thank you, guys.
Thank you. Bye-bye. Good night.
The item on the agenda today is just to, as a result of the public hearing we had regarding the name change of the Clayton Trail, this is just signing the resolution approving that based on no comments received at the public hearing.
Okay.
This is the formality piece.
So moved.
I beat you to it, didn't I?
It's 18-009.
Second.
Commissioner Claypool?
Yes.
Commissioner Lennon?
Yes.
Commissioner Spudler?
Thank you. Have a great day.
Okay. Thanks, Nick.
And I apologize
Thanks for your
that
help.
she had another meeting to go to.
This is just an acknowledgement of appointments. This is not anything, you did the rest of these during the reorg motion meeting portion of the board. So this is just community development, requesting the board acknowledge Jonathan Ferguson and Roger Anderson as appointments to the Tax Incentive Review Council as representatives for Parkland Township for a 3-year term ending December 31st, 2020.
So moved. Second.
Commissioner Claypool?
Yep.
Commissioner Lennon?
Yes.
Commissioner Spudler?
Right.
You're up.
I'm awake now.
Happy birthday. Did you celebrate one while you were sitting here?
Just want to know if I can get the 2.5 hours back.
We're not there yet. You still got another 10 minutes.
Hi, everybody.
Hey,
All right, so we
Nancy.
got the next 3 items, and Nancy's here for the 2 of those 3 items.
Good.
Quickly should have, I think the board president should have
for number 16, a list of assurances which need to be initialed, which I believe I already initialed my portion.
You did.
Thank you. And this is just so we can receive the administrative portion of the PIP grant, which is percentage income payment plan program, which is for us to administer that program, which is affiliated with the HEAP grant that we get for the heating, houses in the winter for those that receive gas. So that's really just what we need to submit these assurances so we can receive that grant.
Okay.
The Department of Job and Family Services is requesting the board approve the submission of the DY 2018 Percentage of Income Payment Plan Program PIP Administrative Grant in the amount of $7,257, and further approve and authorize the President of the Board to initial the assurances for the PIP.
So moved. Second?
Commissioner Claypool?
Yep.
Commissioner Lennon?
Yes.
Commissioner Spudler?
Right.
Thank you. The next one is is to essentially execute the mutual funding agreement for Family First Council, which we come up every 6 months to do that. So that is what the next resolution is for.
The Department of Job and Family Services is requesting the board approve and execute the Geauga County Family First Council mutual funding agreement between the Geauga County Board of Commissioners, Geauga County Job and Family Services, Geauga County Board of Developmental Disability, and the Geauga County Board of Mental Health and Recovery Services for the funding of the Geauga County Family First Council for the period January 1st, 2018 through June 30th, 2018. This agreement commits the Board of County Commissioners to provide a support payment of $42,484 from the general fund.
So moved. Second?
Commissioner Claypool?
Yep.
Commissioner Lennon?
Yes.
Commissioner Spudler?
Right.
Thank you very
Good.
much for all
Thank you
your
very
support.
for your
Oh,
support
yeah.
for the
Yep.
You all are
Continued,
great.
yeah. That's great.
And you've been a great addition.
Thank
and,
you.
uh,
I enjoy
so-
it. Yeah.
Good.
Good
We
things.
very much appreciate you
Yeah.
being so supportive of what we do.
No, you guys do. You guys work hard. It's
Hopefully.
that's what it's all about. You know, all this other stuff that comes down to taking care of kids in this
Right.
county. You know, I think that's the precedence there, for sure. You
Well,
guys,
you
I know
know-
you work hard on it. Yeah.
We do, we all work hard, but
Yeah.
you're very supportive, and we very much appreciate that.
Mhm.
Makes a huge difference.
Good.
And the next one is also for Nancy and I, is for the Ohio Children's Trust Fund. You guys are responsible for appointing the child abuse and neglect prevention specialists, which you have previously with Nancy and I, so we can, again, continue to participate on that Regional Prevention Council. And so our term ended at the end of last year, so we're just asking for you to reappoint us to that position.
Okay.
You are
Who's in
so-
the region? I mean, what-
Okay.
Ashtabula?
Yeah, Ashtabula, Cuyahoga, Lake,
Lake.
and Lake.
Lake and Lake.
Yeah, 2 lakes.
Everybody's working pretty well together, though, which is great.
Wow.
It's a
That's
very
good.
good board. And everybody's being very collaborative.
Yes.
So we're all hoping to stay because we've just sort of gotten momentum. And I think Craig and I are probably among the more
Active.
vocal and active. But they're starting to make progress, and so,
Do you have you?
And Sarah Latorette is also, you
Yeah,
know,
she's-
she's been very helpful.
Yeah,
and-
there's that.
she's the head of the whole
Yes.
children's trust fund.
Yes.
Yeah.
Yeah.
Are you? Were you able to set up a time to go to Trumbull County and look at their?
I'm
center?
hoping to do that within the next, we were just talking about that at the
Yeah.
last, so I'm hoping to do that within the next couple of weeks.
Oh, good. I look forward to that.
Yeah.
You know. Okay.
Is any truth to the rumor that I heard there was a young boy taken away from his parents because his mom beats him? And the judge asked, who do you want to be put with? He says, put me with the Browns, they beat nobody. Was there any truth to that rumor?
The what?
I just checking.
I'll give slap that.
The Browns.
Do I have to answer that question?
Yes,
like,
yes,
what?
Commissioner, that's 100% true.
I said that to a no-actor person, and they said, really?
Okay, so the Department of Job and Family Services is requesting the board approve the appointment of Craig A. Swenson and Nancy Silbach to the Ohio Children's Trust Fund Child Abuse and Child Neglect Regional Prevention Council for a 2-year term, January 1st, 2018 through December 31st, 2019.
Just do both. Just say
A motion? Motion.
So moved. Second?
Commissioner Claypool?
Yep.
Commissioner Lennon?
Yes.
Commissioner Spillier?
Thank you.
Thank you very much.
All right.
Appreciate it. We'll be in touch soon.
Yep, thank you. Thank you, Nancy.
Thank you.
The assurances to help register.
Yeah.
Or a tie and everything.
For your-
I can work that way.
Okay.
This must be
I'll
real
send
important.
them.
Okay, cool. Thank you.
You're welcome.
Thank you, guys.
On this one, it's another sticker down there.
He's seen the light.
I don't know what that last sticker is.
about that.
What's that last sticker?
Did we miss one?
There's 3 pages that you have to sign, sorry. It probably got moved in.
This has a different set of names on it, though. Christopher Galley?
No, that's the same as the page before you.
Or just write county commissioner?
The right side is county commissioner, there's just, it was 3 pages,
No,
but the sticky
we
probably
must
just
have
got
missed
moved
it.
in. So yeah, you'll have to have Tim and Ralph sign the
Okay.
last page though.
All right,
Okay, Glenn, you got 3 seconds.
fire away.
What is this guy name?
No,
Yeah.
no.
No? Good?
Yeah.
Safety centers, we know is one of the buildings we're gonna keep for a long, long time, so.
Yep.
One of the things we've been looking at is trying to get all the outside lighting to LED. We had 3 companies look at it. The one that we picked comes in the cheapest with the rebate and everything. A lot of learning on this since October, a lot of stuff with this whole thing. So we're looking at anywhere from a 4.6 to a 5.9 payback in years on this.
Oh,
With
good.
the savings that we'll have changing all our outside lighting.
And that'll cover your initial cost of it. Yeah.
Getting guarantee in the savings?
No, you're not. And that's the problem with the energy world. I mean, today I can come in here and go, yes, I can save you this amount, and tomorrow it's gonna be a different price.
Right.
It goes day to day. So it's very hard to come back and say that. And that's why you give that 4.6 to like the 5.9.
Right.
Year back. So it could be 4.6 or it could be, depending on the price, it be 5.
Right.
Something like that, so.
The moral of the story is it's saving you some money.
Yeah, it will be.
Yeah.
They, they comply, I think the Munson Township probably has like a light pollution reg in their zoning or something as far as the cutoffs, so they're not.
Yeah, they did a light reading and everything out there.
Yeah.
2 of the companies did, and then we had one come in and do a light reading.
And they'll do the install?
I did that so that I could see down the road what the difference is.
But I mean, there's some townships, I think, are concerned with light pollution where you can't see the stars anymore, and just they put in regs that, you know, it's got a cutoff, so it's not affecting visibility of the
I'm
stars.
sure, I'll have to look into that, but I'm sure my security at the safety center.
Well, I heard they liked the, for their security cameras, actually, these new lights, it's gonna make the cameras work better. So, yeah,
It
yeah.
spreads out a little bit more and it
Yeah.
goes down.
Yeah.
So it help when they get different light on you, it look better?
Well, yeah. You know, like reading license
A whole lot of
plates,
light.
reading license plates and stuff like that. Yeah.
I didn't know that.
Yeah.
Well, skipping 4K.
Yeah, it's
Yeah.
Yeah.
But no, I appreciate you taking the time to put, research in it. And I think eventually, I mean, that building, obviously, we're not going anywhere, so it's good to invest in that and continue to switch as many as you can. And the contract includes them doing the install as well, right?
Correct.
So they'll go up on,
Yep, they go up the poles,
Okay.
they go all, 30-some lights on poles, and then there's 30-some lights, what we call wall packs on the wall around the safety center.
okay.
So.
Are they doing the inside yet, or not yet? No. Okay. Okay.
Are we able to take what we learned here and go elsewhere and have an extended savings?
So what buildings are we keeping? This one I know we're keeping, the safety
Yeah,
center.
right,
so.
right. No, it's a good start.
Yeah.
It's a good start.
Dog warden.
Yeah.
Dog warden, yeah.
County
So,
engineer.
mhm. So
Okay.
that's all I have.
Any other questions? The maintenance department is requesting the board approve and execute a service contract agreement with Shepherd Lighting Solutions to retrofit and upgrade the outdoor lighting to LED at the Geauga County Safety Center during the year 2018 in an amount not to exceed $27,157.
Change the Kingles and added the clips.
So moved.
Second?
Commissioner Claypool? Commissioner Lennon?
Yes.
Commissioner Spillier?
Thank you.
Yep, y'all have a good
Yep,
afternoon.
take care. Yep.
I'm not sure which chair to take, you guys switched.
Oddly enough, I had a full-time person put in their resignation because they are moving and to Lakewood or looking at their kids or something. And this person has been here, I think, about 10 years. So, pretty standard stuff.
So you're not, what are you doing as far as replacement?
Well, I'll keep doing that, you'll be doing that next week.
Oh,
I'd
okay.
like to do a full-time one internally, because I think I have some people that because I'll be replacing them, then I'll have to ask for a part-timer to replace that person if they move on out, so. But,
Okay.
So the transit department is requesting the board accept the resignation of Dan Milhauser, full-time driver number 2210, to be effective January 26, 2018.
Second?
Commissioner Claypool?
Second.
Commissioner Lennon?
Yes. You'll get the hang of this. Yeah.
Commissioner Spillier?
Just enough I got it.
I will say, I did learn a lot today.
Did you?
Oh.
Are you more confused?
Anything
Oh,
useful?
no, no, oh, yeah, very useful, because I have some land, I never really looked at this.
Right.
I probably should pay attention to that in case there's something that might be out of here.
How many people
It wasn't all for naught. But I did not have a beard when we started.
I pay somebody to read my deed, that's for sure. Yeah.
The Commissioner's Office has requested the board appoint Nick Goris as alternate for Ralph Spitaleri at the DOACA Planning and Programming Committee meeting on Friday, January 19, 2018, as Joe is not able to attend.
So moved.
Second?
Commissioner Claypool?
Yeah.
Commissioner Lennon?
Yes.
Commissioner Spillier?
And the last one is just for the board, if you so choose, to go ahead and approve what Bowen has created as far as the phase one final report of feasibility analysis. And then we'll be coming back here shortly to talk about next steps. So,
Second?
Commissioner Claypool?
Yep.
Commissioner Lennon?
Yes.
Commissioner Spillier?
Steve, can
Is
we
that,
add that resignation to your list? Like, I mean, I'm not saying this to be bad,
Well,
but
no, it's
like
like,
3 hours to have a director sit here to be able to, and I think we need to, as a rule, if
Yeah.
there's something like this that comes up, it needs to be put as the last item on the agenda.
Yeah. Move
Well-
it, move it.
I actually had it on as the last item. on
she
the
did,
agenda, and I got
but there was a
it, so
request
we
based on
moved it.
availability of Laura, and I think, well, Ms. Colton, as we saw, I had to leave, so that's why,
Right.
it just says it as a request, that's why I told Chris to move it up right after the Joe.
But as far as like for your list, like to have a director, I
He
mean,
can do resignations.
for
it's just
three,
there was
for
the
3
time.
hours to
Yeah,
be away
I know.
from your department, it's
Yeah,
like,
I know,
I just,
yeah, that's a killer.
you know,
Yep.
I mean, I would.
That was unique. I mean,
Yeah.
hopefully we don't do that every day, but yeah. I agree that, having
Yeah.
people tied up sitting here.
Yeah,
Yeah.
I mean, that's like, we had Kelly here for a while,
Yep.
you know, I mean, a whole day of, half a day of work is gone.
Right, right.
It just doesn't, it doesn't make good business sense.
Where was
I
Kelly?
agree.
Did Kelly have to leave?
Yeah, she is.
Oh, see,
Yep.
So, yeah.
all right. Anything else interesting? Let's see,
Nothing, we'll be
Family
back
first,
here,
we're back next
Tuesday?
Tuesday.
Let's see,
in March, is it, or?
planning. Planning commission.
What happened?
We do have a vacancy for planning commission, if anybody.
Did Dennis send his application in yet?
Or, we,
I
vacancy.
had not received
So if you
anything.
can think of
We
anybody.
do have a name that was submitted for that way. Too. I think Tom Newell submitted this one.
There was a couple, you have 3 that
We
were
have a couple,
submitted.
So we have to take a
So-
look at those and really see what we got.
And I sent those to you.
Okay, okay. I don't know, I'll take one of him. Maybe, we did run an ad, right? We did an ad?
Yeah.
Yeah, Is that still going or no?
Well, I wasn't a recurring ad, I think it was a
Okay.
one-shot.
Okay.
We did it once, it's on, it's
The
still
ad
currently
for the
on
board,
the
if
website.
people will volunteer to
When you
volunteer.
were We did it once in the Maple Leaf, but
It's
the
on the
same
website.
ad is
These
still
things
currently
have it.
posted on the county website.
So we here Tuesday?
Yes.
Yeah, well, you basically clocked out.
I don't know, put the word out, you know, planning commission, mental health, we've got quite a few to fill there too, I think, like 3.
Think so?
That's a tough one to fill.
I mean, I don't know if I don't know if we can get the Maple Leaf to run something, would that be possible?
We could try a press release,
You know,
send a press release and see if they would do a little article for us.
Amy,
We
about
did it
some
at
of
the
our-
same
What?
time. It was in there at the same
can we
time.
do a little press release?
Yeah, I mean, the other thing
Joe?
you can always do is you can also write a letter, to the editor, but I don't know what you're asking for, I'm sorry.
Oh,
Board
no,
appointments.
but
Oh,
a couple
board
of,
appointments?
yeah, board
Yes.
appointments.
That might have to go through ads,
Okay,
but,
Yeah.
okay.
I could put a line in
We
here.
did-
that
we
you
did
have
the
no
ad.
openings, but that's not gonna get as much attention as you. Because the ads also go online, and sometimes they're on like Facebook and stuff too.
Really?
So, it's a pretty good deal.
Joe, do you have a Facebook page?
I don't.
No. I mean, the Chagrin Times, I mean,
I mean,
no,
They've got that on.
no.
No,
I moved to Joe, okay.
thank you.
I think Ralph will soon be able to adjourn them, so.
I was
Yeah.
like.
Yeah.
So what's going on?